The magazine stated that the European Economic Community was using a treaty, its own treaty, its own international treaty, as if it were a constitution. And since then, the European integration has been all the more a legal integration. So the rule of law is in fact home both in the European community and in the European Union, because the European Union was in fact created by means of the Maastricht Treaty.
And it is also expected that all countries acceding to this supranational group are democratic countries respecting the rule of law. In words, internally, the European Union works as a government respecting the rule of law with democratic principle, but on the outside, and this is the basic experience of the Czech Republic, on the outside, for the candidate countries, it gave a democratic dividend. This was not democratic deficit, it was a democratic dividend. This could be in the example of specific acts or system changes, but all the time the European Union was the element stabilizing the democratic processes and the rule of law. But this is not enough, obviously. And we can see one of the main features of the European Union. The developments in the member states are reflected in the European Union and vice versa. The developments of the rule of law in the Czech Republic are highly important, and I'm very glad that I'm sitting in this panel next to the former President of the Constitutional Court. Because there is one exceptional thing in the Czech Republic. Here in the Czech Republic, as people say, we have managed to create a comprehensive jurisprudence of the Constitutional Court. This was done by the first Constitutional Court, and when the second Constitutional Court was established, many people were skeptical. But we can see clear continuity here. And the Constitutional Court of the Czech Republic works as a pillar of the democratic state respecting the rule of law, and it is a model showing the technique but also the law ethics for the judicial system. These were some comments on the links and relationships between the systems. Let me also say that we need time for the rule of law. By coincidence, yesterday I attended one event in Oxford in Corpus Christi College, and I could see the workspace of my colleague in which the King James Bible was translated. This is a Bible that is 400 years old. You don't need to have a written constitution if you have the unwritten traditions. But the problem of the Central Europe is that there are traditions, of course. We do have traditions, but they are weak. And they are not respected due to changes of the political regime. And this creates mistrust, cynicism, and as I described this in the written text, the political cynicism and legal nihilism. This is something that we have seen over the past decade at least. And it's important to say that the rule of law is not only a technique, a method, but this is also a political culture and legal culture. This legal culture has been shaped in the European Union for over 50 years. And at the same time, it reflected the individual national cultures. This is obvious. I'm sorry, please, could you give us your last thought? Yes, obviously, I'm approaching my last thought. We had a shortage of time to develop the rule of law. And for this reason, to use law as a tool for a political conflict is an easy pattern that we know from our past. That is why the populist governments in Hungary and Poland did not emerge just like that. The Hungary of Orbán reminds us of the past Hungary, the clientelist state. And we would find similar traditions also in Poland. And by the way, legal nihilism can be also found in the Czech environment. To conclude, I would like to say that it's good that we have the European Union because we can use the dividends of not only democracy, but also of the rule of law. If we have a different result of the elections in the Czech Republic, I would be more skeptical. There is a certain hope in the relationship between politics and rule of law, and we still have a chance. And this is something that is well known to the judges, and we need the politicians to be well aware of this as well. And I think that we have a reason to always look on the bright side of life, but we should never forget about the dark traditions of this part of Europe, and we do have quite a lot of these dark traditions. So we should be careful about them. Thank you very much for your attention. Thank you, Mr. Přibáň, for your introductory presentation within this panel and for your conclusion, which mentioned the hope. And I will now pass the floor to Mr. Pavel Svoboda. I will probably need assistance from the organizers. Okay, great. Ladies and gentlemen, to speak after Professor Přibáň, that's a great challenge. If we are to discuss the value of the rule of law, then I think that we need to first look at the existential role that law has played in the European integration. Today's EU doesn't have a police, it doesn't have any customs officials, it doesn't have an army. It only has law. And so for the European integration, we can paraphrase the slogan of Beatles, all you need is law. The level of identification of the EU with law is so high that the European Court of Justice says that the Union is a union of law in which individuals have the right to challenge in legal proceedings the legality of any decision or any other national act relating to the application of a Union Act against them. What exactly is the rule of law? Since last year, we have had a legislative definition of this. And as you can see on the slide, I would like to emphasize that it includes the principles of legality, legal certainty, prohibition of arbitrariness of the executive powers, effective judicial protection by independent and impartial courts, separation of powers, and non-discrimination and equality before the law. Among other things, the rule of law is one of the values of the EU. It is specified in the preamble of the Treaty on the European Union, like the Article 2 of this treaty. The values of the EU are not just an icing on the cake of the European integration. No, this is an important ingredient of the functioning of the Union, as has been specified by the European Court of Justice. The European Union is composed of states which have freely and voluntarily committed themselves to the values stipulated in Article 2 of the treaty. And EU law is thus based on the fundamental premise that each member state shares with all the other member states and recognizes that those member states share with it those same values. And this premise also reflects the existence of the mutual trust of member states and especially their courts in recognizing the values on which the Union is based, including the principle of the rule of law. So this is a trust in maintaining or following the EU law. For me, the key word here is trust. The world around us is based on mutual trust, from families to the financial system, for example. And the European integration is also based on the trust, on the confidence that we are creating a club recognizing the same values. I'm sure that we will hear a lot about enforceability of the value of the rule of law. So I will just comment on the regulation which provided the definition of the rule of law. Or let me give you a comment on its efficiency. The regulation that we have discussed so much in relation to Poland should not be used to sanctioning of any breach of the principle of the rule of law, but only the breach which in a sufficiently direct way breaches or affects or seriously risks affecting the sound financial management of the Union budget or the protection of the financial interests. Furthermore, in Article 3, the regulation includes a demonstrative list of breaches of this principle of the rule of law. For example, endangering the independence of the judiciary, limiting the availability and effectiveness of legal remedies. And Article 4 provides more details in this respect. However, the breach of this principle must also be connected to the financial system, and high intensity of such breach must be demonstrated. So, to be sanctioned or to provide a sanction, you not only have to prove that the independence of courts is endangered, but that also such a breach significantly threatens or influences the financial interests of the Union. In Poland and in Hungary, we have seen an attempt to politically control the courts, to limit the media, education, and the LGBTIQ. But When the government, for example, wants to have more influence on appointing courts and their careers, it doesn't seem to be an attempt to make a financial breach on the Union. So, sanctioning of breaches of the rule of law using this regulation will probably require lots of efforts in the interpretation of the regulation. You have received folders with the documents, with the conference documents, and Professor Přibaň shows that the law of the EU is in fact made for expectable situations and for good weather, not for the stormy moments. And these moments are sometimes dealt with by the member states by breaching the EU law. But the EU institutions should only reproach the member states for the breaches of the rule of law if they put their own house in order. The Prime Minister Morawiecki this Tuesday said that the EU institutions use a double standard and that the European Court of Justice is creative in its interpretations of the treaties and that it is extending the powers of the EU to the detriment of the member states. Can we say that these findings are unjustified? Well, not entirely. As for the first comment, is there a double standard? Well, I'm a huge proponent of the European integration, but I can criticize this a little bit. If you followed into 2018 the discussion relating to the Sargentini report on the rule of law in Hungary, then you probably had a perception of a double standard. This was the first time that the European Parliament used its powers to activate Article 7 of the Treaty on the Functioning of the EU to protect the values of the Union. During the voting in the European Parliament, you had to choose whether you would vote according to the or with regard to the general situation in Hungary, where there was corruption and nepotism, or you would really vote about the report whose quality was awful, because there were partly lies and it was reproached to Hungary what functions or what works in other member states as well. And this is a pity, because the true part of the report would be enough to reproach Hungary. And as for the second statement of Mr. Morawiecki, does the European Court of Justice really extend its powers? Well, this is not a rule, but we can find some examples like that. For example, the ruling in the case of Koman in 2018. This was a same-sex marriage between a Romanian and an American. The marriage was established in Belgium, and the American then asked for a permanent residence permit in Romania. And in Romania, same-sex marriages are excluded. The Court of Justice, however, ruled that according to the Article of 21 of the treaty, that this article shall prevail over the family law articles of national law. Although, of course, these kinds of areas are not subject to the European law. This is not related to free movement. And this is something that the European Court of Justice should respect when respecting the principle of legality. And it is a pity that these examples give the ammunition to people like Morawiecki against the Union. However, these shortcomings on the part of the EU institutions are rather an exception from the rule that the EU is really a union of law. Moreover, these minor examples don't justify any breaches of the rule of law, be it in Poland, Hungary, or elsewhere. In a few days, the third chamber of the deputies will be established, which will have to deal with the scandal of the stork nest, Čapí hnízdo. So that's it for my presentation. Thank you very much for your attention.
Tak já moc děkuju panu.
Mr. Svoboda, thank you for your opening speech. And now I would like to hand over to Angelos Chrysogelos. Angelos Chrysogelos is connected online with us. So I would like to ask Angelos to switch on his microphone, and we would also like to see him on the screen. So thank you. I can hear you, yes.
Many thanks for the invitation. It's a real pity that I'm not able to be there with you. Of course, Prague is always a great place to visit, and it is also a great honor to be part of this panel concerning rule of law. And of course, it is a big challenge to be to offer some comments following on the other comments that we heard from eminent speakers who are in many ways much better placed than me to discuss questions of law and the rule of law in the EU. When the invitation was made to me to participate...
Já se moc omlouvám, pane Chrysogelosi, že vás...
Mr. Chrysogelos, can I ask you maybe to speak a bit more loudly? Maybe a bit more loudly. So thank you for that. So thank you.
Okay, I was actually speaking not too loud, not to be too loud. Okay, I can be loud. So when I was invited to present in this conference, and I'm not a lawyer, I thought to myself that perhaps the way I can add to the conversation is to actually bring a more political perspective to the question of the rule of law, because law and the rule of law do not take place in a vacuum, but of course they form part of an overall political debate and an overall political climate and political moment, as we see currently in the EU, and particularly with what goes on, especially in countries like Poland and Hungary. I also believe that in order to have a good debate, we don't need to agree on everything. And while I do not disagree in principle with what the previous speakers said, I think it's still important to be a bit more critical about the way the EU works, and to actually ask ourselves about why the EU is facing so many problems with the rule of law currently. Of course, one way to say this is that basically what we have is that we have a few bad governments entering power in some countries, in the case of Hungary and in the case of Poland, namely. So essentially, we get populist governments, and populist governments, as we know, tend to tend to negatively influence the independence of courts. Hence, we have a problem with EU law we have a problem with rule of law in the EU. However, to me, this only pushes the question a bit more, which is, why do we get such reactions? Why do we get the rise of populism in the EU? And why do those governments feel the need to meddle with courts, or feel the need to meddle with the EU law, with the principle of the supremacy of EU law? And to my mind, this unfortunately has to do also with some unperfect or incomplete dimensions of European integration. Now, as the previous speakers said very eloquently, the EU is, of course, a system of supranational, multi-level, complex governments that relies on the principle of law. In essence, it is law that makes the EU move forward. But we also need to ask ourselves where does this leave any space for politics? Because we know from our national systems that the rule of law is not the only element that constitutes our liberal democracies. Rule of law exists to basically be the arbiter, the referee of a political process, but it is not meant to be the substitute of a political process, all right? In an ideal system, the way we understand liberal democracy, it is the people and it is elections and it is politics that makes decisions, and the courts are there to arbitrate between different interpretations of these decisions and to safeguard the rules of the game. All right. So in a way, courts and the rule of law exist to monitor the rules of the game, but courts are not meant to determine the outcome of the game a priori. And I would argue that unfortunately, currently, what we have in the EU is a clash between two rival interpretations of what democracy means, and particularly what democracy under the principle of law means. And I would also argue that we have to be quite realistic, also for people in this room, that even though all of us are attached to the principle and to the value of the rule of law, the opposite side of the debate, which says that democracy is all about the will of the people, is not an illegitimate position. It is an extreme position. It is a radicalized position, but it is an extreme interpretation of what is a legitimate position. And I would argue that, of course, the EU operates under the principle of law, but this also opens the EU to problems that we see in other countries as well, namely the United States, where there is a sense that a lot of moving forward, a lot of political decisions are being made by courts. And this can happen either because politicians want to avoid the responsibility of making difficult decisions, and this can also happen because courts themselves are institutions. Their institutions are always interested in expanding their scope and expanding their remit and expanding their powers. So I would argue that in the EU, what we currently have is we have a problem whereby while rule of law exists, we have kind of lost sight of the fact that rule of law was always part of specific national compromises about how liberal democracy should work in a country. In a way, we speak about liberal democracy in the singular, but in fact, historically, we have many liberal democracies in the plural. And liberal democracies, different liberal democracies, organize politics and the balance between elections and the rule by the many on the one hand, and the rule of law and courts and protection of rights, and even more importantly, what those rights are on the other, in many different ways between countries. Now, what you have in the EU is you have basically two trends that, to my mind, feed this populist reaction against rule of law that we see now. The one trend is the trend of internationalization, the idea that basically major elements of the rule of law are taken away from the national level and transposed to the supranational European level. And this is very good for populists because essentially they can present their assault to national courts as a defense of national sovereignty, because by taking control of national courts, they can essentially say that they are repatriating the rule of law from supranational legal authorities. The second problem that I see is what I already spoke before, is this notion of judicialization of political decisions. The previous speaker mentioned the example of the Romanian case, which actually I wouldn't dismiss it as an exception or as something that is unfortunate, quote unquote. I think it reflects a very uncomfortable trend whereby principles of the common market are reinterpreted in ways that go to the core of the values that specific societies espouse. And again, this gives fodder to populists because essentially they can say that their assault on courts is a way to both defend national sovereignty and traditional social values in their country. We know from opinion polls in Poland that the vast majority of the people there are actually against meddling with courts. In Poland, the independence of the judicial system is highly valued as perhaps kind of the most one of the most precious elements of the post-communist transition. But we also know that the moment this assault on courts is framed as a defense against the liberal values imposed by Brussels, etc., then the calculation changes, and there Law and Justice finds a space to actually attack the courts. Now, by all of this, of course, I don't mean to say that it's the EU's fault that the rule of law is under assault in various EU member states. But we have to ask ourselves, is there something about the way EU integration exists today, and particularly its over-reliance on depoliticized processes of legalizing political problems and removing them away from the purview of national politics and national elections, essentially removing choice from what people can vote on? Is this something that inherently feeds radical over-politicization reactions like the ones we see from populists? Therefore, while of course dealing with the problem of rule of law and the challenges that exist within countries like Hungary and Poland specifically is important, we also have to ask ourselves, is there some ways that the EU foundation has to reassess the way it works so that those problems don't appear again with even more intensity in the future? Thank you very much.
Tak já moc děkuji.
Thank you very much, Mr. Chrysogolos. And I'm passing the floor to Mrs. Ivana Iannou. I will ask her to give us the introductory word. Ladies and gentlemen, thank you. First of all, I would like to ask the Institute for Christian and Democratic Politics for inviting me to this conference. Based on my membership in the Institutional Court for almost 2 generations, I would like to say a few words about the functioning of the rule of law. If we are to assess the importance of the rule of law for the functioning of the EU, we have to say that it is one of the values that is common to all member states. This is the common internal mechanism of the whole Union. And for this reason, we must respect and follow these principles in our day-to-day lives and in the area of law. That is why I have welcomed the report of the Commission on the rule of law in the member countries in 2020, as well as the mechanism of the annual assessment of the rule of law and its respect. in the member states of the EU. In the long term and on a daily basis, I observe the changes in the political life and in society in the Czech Republic. And I'm convinced that the democratic and legal character of the Czech Republic has been weakened. There are signs of authoritarian regime. And we heard a number of times that the Chamber of the Deputies is just a chamber for discussions, and that the government is populist. Also, there is a lack of using the checks and balances that are provided by the Constitution, and this means a deformation of the separation of powers. What we have witnessed is, for example, the inherence of president in the personal composition of the government. This has led to a media response of the Prime Minister, who says that it is the president who should influence the composition of the government. This has weakened the role of the Prime Minister, not only the current one, but especially the future Prime Ministers. And this will also affect future governments and chambers of deputies. I have appreciated the results of the elections, not only because of the political parties that have now won the elections, but this may represent a change in the functioning of the democratic system. In Article 1, Paragraph 1 of the Constitution of the Czech Republic says, the Czech Republic is a sovereign, unified and democratic state based on the principles of dignity and respecting civil rights. This is important because this may be in clash, in contradiction with the principles of rule of law. The rule of law is a corrective element for the majority. It respects the rights of the minorities. It has to protect them. And the preamble of the Constitution also provides some details of this. And few people know that the author of the preamble was Václav Havel. A preamble usually shows ideology, premises and goals of the piece of legislation, and it is an important element for interpretation of the piece. In 1993, we stipulated that we, the citizens, are ready to develop and protect our country in the spirit of the intangible values of human dignity and freedom. As a country of equal and free citizens who are aware of their responsibilities towards others, solidarity, and responsibility towards the whole country, a democratic country based on the respect of human rights and on the principles of civic society, as part of the family of European and international democracies. We are ready to follow all of the principles of democratic state that have been proven. And also Article 9, second paragraph of the Constitution is linked to this. Changes to the fundamental elements of the Constitution are not accepted. This is the core of the Constitution that cannot be removed by voting or by any other changes. And in case Melchák, the Constitution Court ruled that the Constitution can be amended and modified, but no ad hoc exceptions and exemptions from the Constitution can be made. Article 9 was incorporated as a response to the multi-annual breach of the rule of law by the communist regime. The Constitutional Court of the Czech Republic made rulings, hundreds of rulings, and you will find the information in Annalus, in the Constitutional Court. There are about 500 such rulings. So that this is the corrective mechanism which first happens within the national states. Most rulings of the Constitutional Court were based on the breaches of the legal principles in specific proceedings. But we have to distinguish the deficits of law from minor breaches of the rule of law, because there was an attempt to reach a fair case. There is a difference between the Czech rule of law and the Anglo-Saxon rule of law. There is a certain content, what is fair, what is just, then also what is just based on the morals, morality, and the natural law. The Constitutional Court also said that our legal system is not only a system or a group of case law, that it also includes ideas, ideology. Because there were some laws that could not be annulled immediately. We needed some legal continuity, and we needed to reflect on the value discontinuity with the communist regime. And until today, we can hear that we should have annulled the former law. This is hard to do. But the Constitutional Court made a ruling in which it said that there was lack of legality of the communist regime. And this interpretation was given to the courts so that they can reflect on the change in the system. Professional literature shows the main elements of the rule of law. There are 9 such elements. I will not read them all. This is a separation of powers, saying that the individual elements have limitations and they should check one another. So this is the system of checks and balances. And in our system, each of the powers is divided into 2 sub-branches. The executive power there are 2 chambers. We have the president, the legislative power is divided into 2 branches. Then in the executive, we have the president and the government, and so on. The judges and the rule of law are bound by legislation and by the constitution. There is a prohibition of arbitrariness of the executive power. Then we have also the court reviews. You can appeal to courts if you want to protect your fundamental rights. Legal certainty, that's another element, the principle of reasonability. And civil society is considered to be an equal partner to the state. This leads me to the judicial power. It has many roles in the rule of law. It should check on the other powers of the state. This is where the Constitutional Court usually steps in. Or it should check the regional courts, where it should, for example, correct or check the decisions made by the Ministry of Health during the pandemic. The judicial power makes these checks, and that's why we have more requirements on it. We want this power to be independent, impartial, and so on. Independent courts should primarily protect law. Law is a set of rules of behavior, and it is anchored in the morals of society. Morals are the anchor of law. Barak, professor at the Constitutional Court, said that we need morals for our law. The judicial power needs to be independent. This independence is highly important, but what is even more important is the personal selection of judges. They need to be professional, but what we should also assess is the personal integrity of the judge. They should be able to decide based on their discretion. They should be highly independent and impartial. Justice should always be present in the decision-making of the judge when he assesses the merit of the case and interprets the law. Because justice is one of the principles that is perceived in the most sensitive way by people, and together with other principles, it is present in the whole order of the law. The Constitutional Court has an exceptional position in the rule of law. The Constitution says that it is the body protecting legality. Apart from protecting the fundamental rights of citizens, it has also other important powers. For example, it decides on the annulment of acts and their parts. It decides about the constitutional complaint against president based on the Article 65. Then, of course, it decides about the Article 66, which is something that we are now experiencing in the Czech Republic. It decides about a dissolution of a political party, whether this is correct. And in first instance, this is decided by the administrative court. It is also a court of appeal as regards the election issues. There are 15 constitutional judges. They are appointed by the Senate, or they are selected by the Senate and appointed by the President. That's why the role of the Senate is very important. And if someone says that we don't need the Senate, then this is misplaced from the perspective of the Constitutional Court. I would also like to say that the idea of the rule of law should not be depersonalized. From a certain point of view, this is a guarantee for free development of each citizen. Based on my many years of experience, I would like to say that based on the Article 1 of the Charter, we are all equal in our rights and in dignity. The fundamental rights are inalienable, inseparable, and they cannot be annulled. And human dignity is connected to all other human rights. This is a principle characterizing the base of all living people, and it requires protection. And morals and justice are the other values or principles. It is well known that human rights and their protection are only guaranteed in democratic government systems, where there is a separation of powers and when there are checks and balances.
So we have the checks and balances, as you know, the system. In autocratic systems, there is very little a guarantee of protection of the rule of law. It peters out. In association with the rule of law, we must also mention the watchdog of democracy, media. But I mean independent media, because of the media play a good role, then they play a very important role because of the investigations. The media ask the questions, inform, and the media also have access to information that the public would not get. And the media also reflect on the government and on the governance. And it would be advisable for the media to reflect even upon favorable principles in politics. During the COVID pandemic, the civic society has really proven to be very reliable in helping other people. The civic society has also proven that solidarity is not an empty notion. We can, for example, refer to the association Milion chvílek pro demokracii, Million Moments for Democracy. The number of demonstrations has shown that a democracy has taken roots in the Czech Republic, and that many people do realize what democracy means and that it must be protected even from the government. Thank you for your attention. Mrs. Janu, I would also like to thank you for your opening speech. Now I would like to open the discussion. We heard here a view on the principles of the rule of law from various perspectives. For the beginning, I would like to have a question, the same that goes to all of you, and I would be very happy if all of you could respond to the first question. I will first stick to your expert view on this matter. I would like to ask you why, from your perspective, it is important that the principle of the rule of law is observed, that it is respected. So why should the principle of the rule of law be observed, be respected? So let us start with Mr. Svoboda. So the same question goes to all of you. So why can't you ask an easier question? Ubi societas ibi jus. There is society, there is law. And I believe that the principles which are really a part of the values of the rule of law allow us allow the society to live together. Maybe we might also divide it by various segments of the rule of law, but if you allow me, I will now present a very provocative perspective. So if the former Vice President of the Constitutional Court was talking here about the elections, then I would like to state the following. Excuse me, I need to cough. If the government or if the public authorities do not feel bound by the law, the citizens will do exactly the same, the population as such. And if we approach the legislation and the law in this way, if we disregard the legislation and if we exaggerate a bit, then it does not matter whom you elect as your members of parliament, because the legislation adopted by the parliament will not be observed anyways. So I'm exaggerating a bit, but I think it really has a very encompassing effects. So that is why I'm repeating, there is a society and there is the law. And without the law, a society cannot exist well. Otherwise, the society will be biting at itself. Because the people might only try to sort out, to sort out the troubles between them on their own, but it might cause troubles between the governments. I'm now handing over to Mrs. Janu. I think when I was delivering my speech, I emphasize the importance and significance of the rule of law. The underlying idea of the rule of law is that the government feels subordinated to the principle of the rule of law, and it is very important, and it's a typical feature of democratic systems. My experience from the Constitutional Court is that every ruling of the Constitutional Court was really just a piece in the puzzle of the democratic rule of law, and we've been building this puzzle, this mosaic, very slowly the past 30 years. And the erosion of the rule of law has been enormous in the past few years. And I think it simply means that the society becomes coarse. The moral is really extremely important for the law, for the rule of law. You can have excellent rules, but if the society does not absorb the legislation, if the legislation is not really accepting it, then it is a piece of paper that you can throw into the basket bin. The rule of law is never complete, it is never finished, it is still in the building process. But I always find it a pity that once we have laid the foundations, and you can see that Václav Havel was really one of the presidents and one of the politicians who really respected and saw the law as really the fundaments, and he realized that we are all equal before the law, be it for governments or for the citizens. For example, if the new government enforces and supports more ethic and culture, I would very much appreciate it. It was a very suggestive question. Why does the government need the law? Because it is the only language of the government. The government can only speak in legal terms. And we experience, in fact, the government through the law. It is, in fact, the first idea of the rule of law. The government is not as important. What is important are the legal standards that regulate and govern the rule of law. By the way, in the United Kingdom, there is no legal entity of the government, so there is no legal definition of the government, of the state, but in fact the way the government acts is in fact the rule of law. We now have a conference on this topic, rule of law in Europe, but I think that it is very important to emphasize what the rule of law means in the individual countries of the EU, because every country has its own traditions, but one thing is common to all countries. Due to the fact that the government can act only through the law, through the legal language, we also know which civic rights and civic obligations we have. And these rights and obligations apply both to the member states and the EU too. It is quite interesting that the European Union is in fact dealing with the same theoretical questions that the governments were dealing with 100 years ago. For example, who is the guardian of the constitution? Hans Kelsen, a Prague citizen, asked this question in a famous dispute with Carl Schmitt in the 1930s. And we are now also just thinking about who the guardian of the constitution is, if it is the national constitutional courts or the European Court of Justice. And there is no clear answer. We can only get the answer by means of some softer tools. The law is not about the cases which are mentioned in this document. What is more important is that the law is also a set of very soft practices, like, for example, the dialogue between the judges, etc. The law is not only a system of hard rules, the law is also a system of very soft practices and the willingness to find an agreement. Thank you. Mr. Chrysogelos, can you answer the question?
Yeah, from a political perspective, I would say that the rule of law is basically the glue that keeps democracy together, that keeps democracy functioning. Because at its principle, democracy has a very kind of dangerous perspective. Because if decisions are to be made by the many, of course, the temptation is that a certain group, once it acquires a majority, it will decide that this majority should stay forever. Or because there is a permanent majority on a certain topic, then that means that there should be no conversation, there should be no debate, or that majority can do whatever it wants. The rule of law basically limits what those majorities can do. And in this sense, it de-dramatizes elections, it de-dramatizes the rule of majority. It means that even if you acquire power, there are important limits to what you can do. Therefore, acquiring power is not really a free ticket to doing whatever you want. And if you are in the opposition, it does not mean that you are condemned to basically never being able to have your views heard or respected. That is why it is very important to understand the rule of law, or to present even the rule of law, not as something that is whose purpose is to only protect the few, or protect rights, or control the will of the majority, which of course it does, but to present it as an essential feature of democracy. As Robert Dahl said, who's a famous theoretician of democracy, the main principle of democracy, the kind of the main advantage of democracy, is that you essentially have many rolling different minorities governing over time, which means that if you add them all up, almost everyone has a stake in the system. And this only happens because of the rule of law. So it is important to understand that, and to also present, and this is what a lot of the people who currently oppose the movements of the current government in Poland do, that the rule of law is not just an aloof, elitist kind of opposition to what the people, as populists usually say, want, but it is an essential feature of how democracy works. But of course, it is also important that the rule of law be safeguarded, because the moment you start meddling with it, one side meddles with it, then another side will feel the temptation to do the same next time it is in power. So apart from an institution, the rule of law is also a value, it is a norm, and it has to be very kind of cherished and reproduced over time, because the moment it appears to be not so well respected, then unfortunately all bets are off about how people will treat it in the future.
Děkuju. Pane Svobodo, vy jste v tom...
Thank you, Mr. Svoboda. In your opening speech, you were referring to the speech of the Polish Prime Minister in the European Parliament. In the speech, the Polish Prime Minister said that everybody can interpret the rule of law in a bit different way. We heard from you how the rule of law is defined in the European law. Mrs. Janu said that we must view the rule of law not only through the legislation, written legislation, that we must also consider the ethics and how it is perceived. Mr. Chrysogelos and Mr. Přibáň was also referring to this. But how can we guarantee the rule of law if we know that it is not easy to define, and that not only the written standards define the written the rule of law? How can we make sure that the rule of law will be respected if the Polish Prime Minister can then state that everybody just has a different interpretation of the rule of law?
It is true that there are different attitudes towards the rule of law and the value of the rule of law. There are stricter definitions of this value, which pertains to legality, binding of the law, independence of the courts, and there are also broader approaches to the rule of law, where it includes also the democracy, respecting human rights, and so on. That is true. However, I believe that agreement on at least the narrower definition of the rule of law has been achieved. We know what the basic framework, what the basic definition of the rule of law is. And if someone says that there are different definitions or notions and concepts of the rule of law, and saying that this is the reason for breaching, for infringing these values and principles by my own government or by the court that is influenced by the political regime, is not adequate. And I think that this was not suitable or adequate for the plenary session of the European Parliament, where it was mentioned by Mr. Morawiecki. This is an argument which was given for a specific person, for a specific purpose. Of course, I would like to say to our other panelists, if they want to comment on the speeches or statements of other panelists, this is definitely possible. If you don't want to comment on this, I will have another question to Mr. Přibáň. In the paper that has been available for this conference, you mentioned the toolbox of the European Union, which is used for the protection of the rule of law. But as we know, we have had issues with the rule of law. We mentioned Poland and Hungary, and the situation has not been resolved yet. At the beginning, we could see, and was mentioned by Mr. Svoboda, that there is the regulation connecting the budget with respect of the rule of law. And there is a clear definition of when the EU will step in. There are more such definitions. But some people say that these tools don't really have any specific procedures, and that they bring no specific effect. I liked what Angelos said. He said that there are some political issues that can't be judicialized. They cannot be transferred to legal issues, and at the same time we cannot politicize legal cases. Law and politics are different. Something needs to be decided by democracy, by the people, and sometimes the judge has to step in. There were 2 Brexit decisions in the UK, and this is a clear example of the cases when the judges should not step in this decision-making process. But they thought that the exit from the European Union intervenes so much in the lives of the British people that this needs to be taken into account. And what is also important was that the referendum was not legally binding, but no one dared to challenge this process. So this is a difference between the politics and law. This also applies to the sanctions. A financial sanction is an efficient tool, a very efficient tool, and I can imagine an extensive interpretation of what the financial interest actually means. What we have seen in Poland and in Hungary is a threat to independence of courts, and the European Court of Justice made a ruling not only against Poland and Hungary. There were also some other cases. For example, a case that is 3 years old of the Portuguese courts, and this year this was a case regarding the Maltese courts. So the European Court of Justice takes the independence of courts as one of the priorities, as one of the values, as has been mentioned by Professor Janu. Financial sanctions can be an efficient tool from the political perspective against poor countries. But the risk is that you will divide Europe into the poor countries, which will be subject to this, and the other ones, like the Netherlands, a rich country which is glad that something has been done in the rule of law, because the Netherlands now deals with the issue of how to explain that the money from their budget goes to corrupt countries like Hungary, and this is a huge issue for Europe. You said that the sanctions might have no effect, but I don't think that Article 7 will have no effect. This article was the so-called Lex Austria. It was created some 20 years ago, and the result of Lex Austria was not successful, but it was a response against the Austrian government made of conservatives, the Popular Party and the party of Jörg Haider. And we could see that there was no breach of the rule of law, and this led to creation of the Article 7 of the Treaty on the European Union as we know it. These articles are rather a political sanction. So we have the financial sanctions and the political sanctions, and I liked what Angela Merkel said yesterday. She said that the rule of law is very important, but this should not mislead us to take or to start any legal fights, legal battles. We need to respect our legal principles, but we should know that sanctions can be both positive and negative. But I'm not sure what to do about Poland of Kaczynski or with Hungary of Orbán. Okay, thank you. And I could see that Mrs. Janu was nodding when you talked about the words of Angela Merkel. How do you perceive the situation in the area of rule of law? I assume that you identify with what Angela Merkel said, that we should not start any legal battles. So what do you think is the way forward in future? Can you see any solution to this situation? Because it has been happening for quite some time now. I'm convinced that in any society we need a discussion. We need to develop a discussion because many issues will be resolved through a discussion. I talked about the concept of the rule of law. All of the countries that entered in the European Union had this vision. And I can see this as the minimum of the values, of the principles. And I think there is no problem to agree about the principles of the rule of law. And only in practice of the individual national states can we see certain breaches of the rule of law. If there is a lack of balance, for example, when you take a legal issue to court, when the base no longer works, just because one chamber of the parliament has reached an agreement or there is no voting process, then the legal system will never reach its objective. And the court should then say whether this is a breach of the rule of law. I don't think that this dramatic dialogue with the Court of Justice is a threat. I am convinced that all states have already been in communication with the European Court of Justice. This is not an exceptional case. This is an issue pertaining to the whole system. The European Court of Justice, as well as the Supreme Courts, always found a solution. For example, the German Constitutional Court came up with the Solange issue. So it's sad that as far as the standard in Germany is higher than in other countries, it will fulfill this standard. And this is something that we also applied when giving higher pension benefits to Slovakians. For us, it was normal to provide higher benefits to the Slovakians because the citizens were not to blame for the separation of the two countries. So again, this was the Solange issue, and we had also a minor fight with the European Court of Justice. But as I said, the debate is beneficial. Let me comment on this. The Czech Constitutional Court in the case Lantová had a special role. This was called cross-fertilization in English. The Czech Constitutional Court actually quoted the German Constitutional Court and its doctrine, Solange. And it's also interesting that in the case of the Lisbon Treaty, the German Constitutional Court quoted the Czech Constitutional Court, but it quoted the part in which there was the quote of the German court. So, you know, this shows that even the judges are just normal, ordinary people, just like we are. Okay, thanks for this comment, and I have a question to Mr. Chrysogelos. Mrs. Yanu said that almost any country had its own battle or fight against the European Court of Justice. Now the focus is on Hungary and especially Poland. At the very beginning, in the introduction to this conference, I said that the rule of law was being discussed at the European Council, which started yesterday. Mr. Chrysogelos, when we have these issues where Poland and Hungary have a dispute or conflict with the European Union, can this influence the relationships among European member states? What could be the impacts of this?
Well, clearly there is a problem when rule of law becomes an issue of conversation between member states and the EU and other member states, and we see it currently with the question of Poland, where basically yesterday in the meetings, yesterday's European Council was supposed to be about energy and was supposed to be about energy prices, and Poland actually raised some issues about the EU's green transition and so on. The problem is that the EU remains at its core a union of states. It remains a union of nations, and it can only exist. And the principle of the supremacy of EU law, so essentially the rule of law on an EU level, which, by the way, only relies on certain rulings by the European Court of Justice. It is not part of. It is not specifically spelled out in a treaty. The only time that it was spelled out in a treaty was in the European Constitution, which was rejected not in Eastern Europe, by the way, but in two founding members of the EU, France and the Netherlands, in 2005. So if that principle does not exist, a lot relies on the political will of the governments around the table. And I would unfortunately note that Poland and Hungary are perhaps the most egregious examples of illiberal governments using or abusing the rule of law in their own countries while basically playing games inside EU institutions to protect themselves. But the overall climate in the EU currently is one of more national sovereignty. I find it particularly amusing to see the Prime Minister of the Netherlands, Mark Rutte, to actually now be a crusader for the preeminence of EU law over national law, who is a prime minister who has won 3 elections in his country using rather Eurosceptic rhetoric. And I wonder if he would ever dare to spell out the principle of the primacy of EU law towards his own electorate if he ever hoped to win an election there. So the problem is that we now realize that rule of law is a value and a norm that must be protected, of course, but it is fundamentally subject to important balances of power, the willingness of politicians to respect it, both in the national and the EU level. And as we saw the result of the summit yesterday, faced with problems in various member states while at the same time having to make important common decisions, the EU basically decides that it is more important to have governments on board for many important decisions it has ahead rather to antagonize them directly on the rule of law. I don't necessarily think this is bad because I'm a firm believer in the fact that such deep political polarizing issues have to be solved from within the societies that face them, from within the nations that face them. So perhaps this is all for the better if actually this drives the point home that it is up to the Polish and the Hungarian people to respect, to make sure that the law in their country is respected and that limits are put to the actions of those governments.
Thank you for that. Now I would like to give the floor to the audience. So if you have a question, so please raise your hand. We will pass the microphone over to you. And also I would like to remind our foreign guests that they may ask the questions in English. We have interpreters available, so please do not hesitate to ask a question in either Czech or English as you find appropriate. Hello, Jan Doležal from the Center of European Programmers and Analysts in Brno. I'm a programmer and analyst of a comprehensive economic software as ERP system since the 1970s, when programming, analyzing a comprehensive ERP system, for example, for large hospitals or large enterprises, we always needed to respect the legislation when programming the IT systems. It's always the same. For example, in socialism, we also wanted to digitize the accounting. Like, for example, the month-end or the year-end closing and the statistics. So when we introduced the IT systems in the accounting, we cooperated with the Ministry of the Interior. And it was lawyers who were not able to advise us, so it was us who wrote the codification of the law for them. So we've been living in democracy for some 30 years, and at this moment the Industry 4.0 is taking place. Engineer Vladimir Dzurilla is responsible for this. He's a Slovak citizen, and he said at one conference that the Czech legislation is simply not supporting the process of Industry 4.0. What does this mean? I really tour the whole world. I attend international conferences of IT specialists, and I can tell you that I really only hear the worst rumors about the Czech legislation. I will not say them loudly here. We always hear even from the politicians that even the lawyers don't even understand the Czech legislation. We must simply get down to it and then codify the individual legal rules so that it's so that the legislation is written in algorithms, so that it is understandable for people, so that it can be applied, for example, in the civil service, in the public administration, or, for example, in the agriculture, etc. The people teaching at the Faculty of Law keep saying that everything is really working well, but when I go to the Parliament, and I go there quite often, and when I see the young lawyers active in the Parliament who have really no experience, and then they maybe have the morale, but they have no expertise, unfortunately, and they have no practical experience. It is absolutely missing. So I did not come here to discuss this, but for a long time we've been dealing with pan-European projects within the IT for Brussels. One project is to be implemented in all 27 countries, and it's quite difficult. It must be handled from Portugal all the way to the east of the EU, and Czech IT programmers are really very skilled. I, for example, met Jean-Claude Juncker, and everybody was really very surprised to see how our programmers work. But when we just descend from the general level to the reality, everything gets worse. Like, for example, the human health. Sorry, I must interrupt you. I would like to thank you for your comment. I think that we understand what you were referring to. Unfortunately, his microphone has been muted. Okay. Thank you for your comment. I think that we all understand what you wanted to tell us. Sorry that I interrupted you, but we also want to pass the floor to other people in the audience. Does somebody want to respond to this? Does somebody from the panelists want to respond to the quality of the Czech legislation? So another question from the audience. Hello, my name is Zdeněk Skalka and I'm from Ostrava. Once again, my name is Zdeněk Skalka, I'm from Ostrava, and I would like to ask you the following. How can we explain to the people, for example, specifically to the people in Poland or in Hungary, that the law is simply more than money? Because even some people in our country do not really understand the law as something important. We have populists who will simply say you will have a higher pension, you will have more money if you elect us. That is what the people want to hear, and some people simply disregard the importance of the legislation of the law. So it is a question to all of you. So how shall we explain to the people that the law is simply much more important than some material values and money? So does some of the panelists want to respond? I think that I really well understand what you mean. You simply want to say that the law, liberty and freedom cannot only be expressed in money. But I also believe that the law is also important in negotiating or finding justice, not only in formal ways, but also in moral issues. For example, if the Constitutional Court managed to reduce the effects of the executions, and if we really manage to abolish the execution legislation as it exists today, then it is the right way. It's also about money, but about the debts, because many people are really highly indebted here. This country is quite egalitarian, but on the other hand, we have hundreds of thousands of people so indebted that they have a seizure of property is really threatening them. These people are really very, very under pressure, and that is why they cannot decide freely. So this is also an explanation of how the law is associated with money as well. And we have another question. Hello, Vít Dostal. I would like to ask you the following question. I would like to ask you a question concerning one of the topical issues. One of the Polish arguments in the dispute between Poland and the European Commission or the European Court of Justice is that the supremacy of the constitution above or over the European law was also confirmed by other courts, like, for example, the French. And that is why it is also mentioned that we do not treat Poland fairly, and that we also apply double standards, and that we only just select the bad examples. So can you please explain the difference? Why is the Polish example more significant, and why should it be dealt with? I think anybody can answer this question, anybody who has the courage to answer it. Thank you for the question. I think that I also talked about it a bit in my speech. In the Polish case, the independence of justice is jeopardized. The independence of the Polish judicial system, it is really more serious than a specific dispute on a specific case with the European Court of Justice. We also had a dispute with the European Court of Justice concerning the pension system, the pensions of Slovaks living in the Czech Republic and the other way around, because of the split of the country Czechoslovakia into two successor countries. But the competency was not established. When I read the decision, the ruling again, I would probably vote as I did before. But one day the disputes must find an end, must be ended somehow. So I think that the way the discussion is led really reflects very much upon the quality, and the court in Europe is also composed of members of the individual member states, and they should also be very cautious to make sure if it will really cause troubles to the individual member state or not. It will cause an explosion. But maybe I might offer a simpler view on the European legislation. People unfortunately believe that the European Court annuls or revokes some parts of our constitution, but it is not true. It is only avoided, circumvented somehow. And I will once again refer to the Polish case. In Poland, it is really about a systemic defect. It is not a single defect. And so before I hand over to Mr. Przybań, I also saw that Mr. Chrysogelos wanted to respond. So please, I'm handing over to Mr. Chrysogelos.
Yes, thank you. I mean, there's 2 points here from a political perspective. And first of all, not all, just because something is calls itself the Supreme Court, it doesn't mean it functions as it should. So, of course, other Supreme Courts in the EU have sometimes made decisions where they challenge the rulings of the ECJ or even the primacy of EU law related to some national constitutions. But we know that those courts operate much differently to what the current Polish court does. So it is clear that this decision has been made in the context of kind of a clash between the Polish government and the EU over concerns of the rule of law. However, what I would say again, trying to be a bit more critical and more self-reflective about how the EU functions, is that this move by the Polish government and the Supreme Court, controlled by the current Polish government, unfortunately was a very smart move, because it It built upon what it knows is already a preeminent opinion across most of the EU, which sees a return to national sovereignty. If the German Constitutional Court has made a succession of rulings over the last 10 years that basically, where it basically wants to safeguard its own role as the safeguard and the monitor of the German Constitution against infringements by the ECJ, even if, of course, the German Constitutional Court is much more independent and serious than the current Polish Supreme Court, still Poland knows that it has an argument to say that there are double standards against it if this current position is being presented as something extraordinary. Unfortunately, in the context of the debate over national versus European competences, it is not extraordinary. And I would remind you that actually Michel Barnier, who is currently running for president in France, has made one part of his platform that he promised that there will be referendums in France every time France thinks that it has to have a law that goes against ECJ rulings. Unfortunately, the political climate in Europe is such currently that the Polish government finds openings for its positions. I think at this point, what we really should be focusing on, and what, when the Polish government tries to have this kind of what about kind of double standards rhetoric, is to be absolutely clear in stressing that the current court in Poland is controlled by the government. That is the core of the issue, not the relationship between EU and national law, because this is precisely the field where the Polish government has an advantage in presenting its case.
Děkuju a poprosím o krátkou reakci pana Přibáně a potom ještě pana Svobodu. Poprosím vás stručně, ať má...
Thank you, and I will pass the floor to Mr. Přibaň and Mr. Svoboda, and please be brief. Just a few sentences. While the other disputes relate to the interpretation, to whether something is ultra vires, whether this is beyond the competencies and powers, the latest ruling of the Constitutional Court is about the impossibility to use a part of the treaty on the European Union. So it challenges the very essence of the legislation of the European Union. And I'm sure that Mrs. Jana Latanovic will give us more details about this. But the court actually challenged the fundaments, the core of the legislation of the European Union. Well, you actually now said everything that I have wanted to say. Yes, it was a part of the promotion, because in the next panel we will have a speaker from Poland, professor who teaches law in Poland. It will be Mrs. Planyavova-Latanovic. So we will expect an answer to this question from her. But let's look at the issue of supremacy of law from a different perspective. If in each given case the judge can decide whether he or she will use the national law or the EU law, if there is such a possibility, such a choice, then the European integration would deteriorate over time. So this is not the way forward. Thanks a lot for these comments. And please, one last and brief question. Hello, my name is Petr Hula, and I would like to ask you what the situation with regard to the rule of law is in the Czech Republic. I know that this is a hard question and that there is no clear answer to this. And what are the criteria for assessing the quality of the rule of law? Is this the length of legal proceedings, as mentioned, for example, by Mr. Svoboda, because you mentioned the Spokes Nest, and this will be the third chamber of the deputies. dealing with the scandal of the Prime Minister. And I'm not sure whether this is related to the confidence in institutions. All of this situation around Czech president, where we challenge the legality of his signature, and the president of the Chamber of the Deputies might be involved in a breach of law. Well, I'm not sure whether this doesn't cause lack of confidence in the institutions. Well, let me say that most of your questions will be answered in the third panel, which will deal with the issue of the COVID pandemic, but also other institutions. How about the question regarding the criteria? Would any one of the panelists want to comment on this? Mr. Přibáň, please. Of course, you can use different criteria to assess the quality of the rule of law. Excellent criteria were defined by Lon Fuller. There were 8 such criteria. And he talked about possible demolition of the rule of law. He spoke about the retroactivity of acts and so on. But I assume that you wanted something else from me. You wanted probably a certain template that could be used to assess the rule of law. It is not so easy, and the regular reports of the European Union, the European Commission, use the criteria of the separation of powers, independence of justice, and what is important and interesting is that it also includes independence of the media. And this may be another question, even if we don't deal with the scandal of the Spork's Nest. What is the situation in which we have independent media, and what is the situation in which they are no longer independent? Another criterion is corruption, and this type of evaluations is done regularly. This may be the transparency issues. And we could discuss the quality or the result of these assessments. And one of the criteria is also the length of legal proceedings. I can assure you that there are certain countries in which the legal proceedings are very lengthy, the proceedings are not efficient, and they know that sooner or later the proceedings will go to Strasbourg, and they already have budgets for compensations for long proceedings. I will not name these countries, but there are fantastic studies showing how the postponed justice can be calculated within compensations. So this is how it works in some of the old countries. Thanks a lot for this answer. I would like to thank you for your attention, for all of your questions, and for the presentations of our renowned guests. Let me conclude the first panel of our conference. We will now have lunch, which is ready in the room on the right side. And let's join here again at 1:45. We will start the second panel. Thank you very much. of the rule of law. To be able to answer this question, we have to define what the rule of law is and what the issue is, how it can be defined. I have not found any definition in the legislation relating to the rule of law. I also didn't see it in case law. There are some rulings referring to Article 2 of the Treaty of the European Union. In various contexts, for example, in April this year, the European Court of Justice made a ruling which referred to the Maltese courts and appointment of Maltese judges. The ruling said that the rule of law is one of the values that the country had to fulfill before becoming a member state. And after joining the EU, the member countries are not allowed to amend their legislation in a way that would deter or reduce the rule of law. So this is the definition of the rule of law. However, in practice, this makes almost no problems, because it is generally expected, and it appears in the Commission rule of law reports, that the term or concept includes work of the justice, independence of justice, checks and balances within the member states, independence of the media, and corruption issues. So this is the basic definition of the rule of law. Oh, thank you very much for the coffee. That is a very fast response to my fundamental right to coffee. So, what does it mean, an issue in the context of the rule of law currently? As I said, the basic definitions can be found in the European Commission's Rule of Law report. These reports were published annually for a few years, and this is a definition of the rule of law in the individual member countries, and each country then also has the country-specific reports, which is a part of the report. The latest report on the Czech Republic had about 22 pages and focused on the areas of justice. It also described the pieces of legislation planning to be adopted, and so on. And it was assessed whether these aspects are aligned with the rule of law or not. But if you only look in the report of the European Commission, you would find out that all member countries, all member states have an issue in the area of the rule of law. So this is not the kind of issue that we would like to tackle now. However, if we look at Article 7, already in 2017, the proceedings pursuant to Article 7 was initiated with Hungary and then with Poland. And the detailed issues related to the rule of law, although it may be by coincidence, are related to the rulings of the European Court of Justice. The country that sends most actions to the European Court of Justice is Poland, and I could see that in the past 22 proceedings were initiated at the European Court of Justice as regards Poland. But if we calculate all of the separate issues, it would be about 45 proceedings. 3 of them were direct proceedings between the Commission and the Polish Republic. All these issues relate to the amendment or to the reform of the Polish judicial system. This reform was launched in 2015, and 4 acts were amended on the Constitutional Court, on general courts, and so on. So in 2010 to 2016, the Act on the Constitutional Court was amended 7 times, and the Act on the Supreme Court was amended 8 times. The European Court of Justice looks into the reduction of the retirement age of judges, and this was also related to discrimination on the grounds of sex. The composition of the State Judicial Council is also being modified, and there is also a reform of the appointment of judges. And there are also some minor modifications relating to the relocation of judges and the disciplinary chamber and its activity, which has been widely discussed. For example, a judge in Poland may not look into the issues pertaining to the independence of courts. It could be persecuted by this disciplinary chamber. So this is an outline of the type of issues that European Court of Justice deals with. If we look at case law, then beyond the proceedings pursuant to Article 7, where I mentioned Hungary and Poland, we should also mention Romania, which is the third branch of issues relating to the rule of law, or specifically the issue of organization of the prosecutor's office. The second area I want to focus on is the importance of the Polish Constitutional Court that is now about 3 weeks old. If I look at the wording of the decision of the ruling of the Constitutional Court, and I'm only focusing here on the wording of this ruling, not on its interpretation, because it's not ready yet, then it says that Article 1, the closer union, together with Article 4, Paragraph 3, the loyal cooperation, the former Article 10 of the Treaty on the European Union, is in contradiction with the Polish constitution. And there are 3 items. For example, in cases where the EU institutions act beyond their competencies. For example, when the Polish Republic cannot assume its sovereignty. What does it mean? This is an instruction for any public administration body that if such an institution thinks that the EU acts beyond its powers, then the EU documents should not be transposed. And there are 2 items relating to the functioning of justice, of the judicial system. The Constitutional Court says that Polish judges may not use the Euro-conform interpretation in the event that it would act in contradiction with the Polish constitution. And I think that everyone should consider this ruling. And why is this ruling different from a ruling of the German court or any other courts? What they say is that if you don't interfere in the core of my constitution, it's all right. But we still have the final say to assess whether the activity of the EU institutions do not interfere with our constitution. They claim this in very specific situations. They provide very specific examples. Moreover, they say that in such specific example, they would go to the European Court of Justice, and then they would analyze the ruling of the court. And only then they would take the consequences for the core, for the interference with the core of the constitution. The Constitutional Court in Poland assumes that the EU law is in contradiction with the Polish constitution in all general aspects. This is the major difference between the previous concepts and previous attitudes of the national courts and the Polish Constitutional Court. And I can also see no other remedy than a change in the Polish constitution. In the items that are perceived as in contradiction with the EU law, and especially in Article 19, where the Polish judges would apply the case law of the European Court of Justice as regards the disciplinary chamber and the Polish judicial system reform. I can see no other remedy than changing the Polish constitution or Poland leaving the European Union. That's the legal perspective. The European Parliament issued today a resolution in which it mentions also a third option. It is asking whether the Polish Constitutional Court is actually complying with the Polish Constitution. It could be said that the ruling passed by this Constitutional Court is null and void. And just one last remark, what should we do about these issues? You know that there was a double discussion regarding the rule of law in Poland, in the European Parliament and at the European Council yesterday. President of the European Commission, von der Leyen, summarized that we have there are two basic legal solutions, either using Article 7 and initiate the proceedings pursuant to Article 7, and the basic item here is that there should be unanimity for all other countries than the country that is part of the proceedings. And if you initiate the proceedings pursuant to Article 7 against more countries, then it can be expected that the two countries will act in partnership, so there will be no effect, and the proceeding would be very lengthy. And what we could also use is to use the regulation on conditionality, which was mentioned by Mr. Swoboda. And the third solution would be a proceeding based on breach of the treaties. There were 3 such cases, and one of them related to the Polish disciplinary chamber. And 2 interim measures were already issued. And this related to the disciplinary chamber. Thank you very much.
Thank you for the opening speech. And now I would like to hand over to Mr. Vít Dostál so that he can deliver his opening speech. Thank you. Good afternoon. I noticed that the organizers always included 1 or 2 non-lawyers into every single panel. So in this case, it is myself who is no lawyer. So I do not want to talk about legal theories, but I would like to view this topic as a political topic, because in my mind it is a political issue. And when I was preparing my draft, I called it the issues of the rule of law in the EU as a problem for the Czech Republic. And first and foremost, I will try to sum up the current approach, the up-to-date approach, so that we know, at least can presume, what is ahead of us in the upcoming few months. And I would also formulate a couple of impulses for the new forming government, which will have to tackle with this issue to some extent. Up to now, the Czech Republic has been pretty cautious. The Czech Republic has not wanted to criticize the situation in Poland or in Hungary. But this has not only been the approach of the Andrej Babiš last government, it has been a continuous approach that was also manifested during the government headed by Bohuslav Sobotka. It was simply based on the consideration that it is a dispute between the European Commission and a member state or two member states, and that the dispute just needs to follow some procedures. The Council and the member states also have a defined role within the discussions in the Council on general issues, but there is no need to play this role actively or to stop it. What's also important is that most member states adopted a very similar approach, including Germany. Germany was first very reserved, and Germany did not show any efforts to be to act on an activist note in these discussions. In the case of the Czech Republic, it was quite interesting to see how Czechia approached the discussion about the link between the rule of law and the funding from the EU budget. It was a discussion which was also led within the adoption of the multi-annual financial framework. Approximately 1 year ago, when the Next Generation EU Fund was adopted, this topic was on the agenda once again. When you read the framework position on this multi-annual financial framework, you will find some very good and rational arguments why the new regime of conditionality is not that necessary, and that most things are in fact manageable or can be addressed within the current rules. The Czech Republic has been quite reserved in the past and did not join Poland or Hungary, or did not simply not approval like Slovenia. So the Czech Republic simply stayed in the calm mainstream. Now, what was going on in Central Europe? This is my second starting point of my discussion. Since approximately 2015, we've been witnessing a ever stronger increasing power of the Visegrad 4 group as a symbol of alliance. It is quite evident in the discussion about migration. I would say that this partnership remains very close. It is still a tight partnership, and I think that the Visegrad 4 group has been keeping a high profile on this topic. And this approach was accepted and even emphasized by the Czech Republic. And the V4 brand was also used by some countries like Poland and Hungary in the field of the rule of law. We can, for example, remind you of the situation when the Hungarian Minister of Justice just said in a interview and that we have a Visegrad interpretation of the rule of law. In this case, it was quite interesting that the Slovakian Ministry of Justice very much criticized this, while Mrs. Benešová, the Czech Minister of Justice, did not say a single word. And it was a very common acting in the Czech Republic when some countries of the V4 group wanted to speak on behalf of the remaining 3 countries. Let us now move on to those 2 countries that are now being discussed most. Let us first start with Poland. In the past 12 to 18 months, we've been witnessing the deepening of the government crisis. It is very often forgotten that we have a coalition government in Poland. It is not only the Right and Justice Party, but this party always cooperated with another 2 parties, Solidarity in Poland and the Dohoda agreement. And they also had a dispute among them, which culminated with the adoption of the new Green Fund. Mateusz Morawiecki negotiated this deal at the European Summit, and then the dispute in the coalition was simply deepening and getting worse. So Jarosław Kaczynski is not really counted on in the future, and there will be a political dispute in Poland concerning his succession. Probably the Prime Minister Mateusz Morawiecki and the Minister of Justice Zbigniew Ziobro will probably then have the contest about who is going to follow. At the same time, the rather more moderate party of Jarosław Gowinowski exited the government, and Gowin was also wanted to have a more reserved position, at least toward the end of last year. And we can also assume that the radicalization in Poland will simply culminate even more. We very often tend to forget the issue with the media liberty, with the freedom of the media. For example, this summer, this problem escalated because the Polish government simply tried to remove one of the private televisions, which is quite critical of the Polish government. And it is a television owned by a US company. So how are we time-wise? So I have 2 minutes. Okay, I will talk about Hungary really very, very fast. As far as Hungary is concerned, we can observe here the efforts to create a circle of very loyal allies. Since Viktor Orban took office, Hungary has been very much focused on good ties, good links in the European Parliament. They also wanted to be quite active vis-à-vis Germany. However, Fidesz exited the European People's Party in the European Parliament, even though it was forced to exit this European People's Party because the number of the defenders of the Hungarian approach is rather diminishing in Germany. However, in the United States, a different presidential candidate won the election than that one which Viktor Orban would have wished for. which means that Central Europe is now becoming really the main playground for Hungary. And that is why Hungary is now turning its attention to Slovenia, or for example to Slovakia, especially to the south of Slovakia. It's been active in its negotiations with Poland, Serbia and the Czech Republic. I think that the developments prior to the elections can testify this. Viktor Orbán simply needs more allies in the European Union, and that is why he bet on Andrej Babiš, because he does not only want to rely on the political developments in Poland. And Viktor Orbán has a very major political contest ahead of him in spring 2022. Now a couple of impulses for the probable new Czech government. Probably we will read nothing about the V4, about exiting the V4 in the political government manifesto, but I would be happy if the V4 group were not praised and if we found a very practical approach. It's quite important to realize that a new government is being formed in Germany. It will be probably more critical of the developments in Poland and Hungary. I think that most candidates can agree on this, that they are simply fed up with Orbán and Morawiecki. I have two more notes. The Czech Republic also had a problem with the conflict of interest of our outgoing Prime Minister. It is now vanishing. And the last one to notion is the weakening of the rule of law in Central Europe also jeopardizes the Czech interests. For example, the Turov case will also be a good food for thought. Mr. Smolek was also present in the negotiations. We can't simply be so sure about the conduct of our neighbors. And when we review the Polish-American relations, we must notice that the United States has shown less interest for Poland, which means less interest for the whole region, which a bit weakens our position. Thank you for this. I would like to thank you for speeding it up, and now I would like to hand over to Jana Plaňavová-Latanovič, and now I would like to ask her for her opening speech.
We apologize, but we can't hear the speaker in the microphone. Yes, that's better. Let me say a few words about myself. I have a strange surname. I was born in Prague, in the district of Vinohrady. And together with Associate Professor Mr. Svoboda and others, I was the founding member of the Department of the European Law at the Law Faculty of the Charles University in Prague. I spent 2 years there, and then I went and moved to Poland due to family reasons. And I first taught at the Adam Mickiewicz University in Poznań, and since 1997 I have been teaching at the Center for Europe at the Warsaw University. And it's no surprise that I teach EU law. And why am I saying this? It's because my comment will show a perspective from the frog perspective. I have lived in Poland for 25 years now, and I have seen many events and developments there. And I'm surprised by the lack of memory in the Polish nation, because when I came to Poland, the first thing that I experienced was an emotional debate relating to the breach of constitutional powers by the then President Lech Wałęsa. This was called the Finlandization of law, and we discussed the balance or going beyond the powers by president. And I was quite shocked by this, because Václav Havel was a very democratic type of person, and I was surprised that president elsewhere is willing to go beyond the legislative powers, and that this can really happen in a democratic country. Today, if you listen to Lech Wałęsa, then I would tell, especially the young generation, that this is the guy who wears the T-shirt with the title Konstytucja, Constitution. So he is on the other side now, and what started under his presidency, when the breaches of the constitution started, then he went very far from this position, and he is doing something completely different. And Jaroslav Kaczynski was the manager of his office back then, so you might be surprised about this. And now these two guys are in huge personal conflict. Could you please switch on my presentation? Because I would like to show you the ruling of the Constitutional Court. Because we are talking about that, I'm not sure whether you have actually seen the ruling. As Mr. Smolak said, we don't have the interpretation of this ruling yet. But I will focus on the proper wording of this ruling. I've been asked to be brief and not be too technical, and not to provide too many legal and technical details. But it's quite obvious, because if you read the wording of the ruling, you will see that it is not as hot as it is presented. So that's the first comment from me. How should I use the clicker? You switch it on the side. Can you help me, please? Okay, that's it. Thank you. What you can now see is the first part of the ruling. I have translated it, so I'm sorry for any mistakes that might be in this translation. I'm not a translator. So this is the third part of the ruling of the Polish Constitutional Court. Mr. Smolak provided the basic analysis of this ruling. What the Polish Constitutional Court says is that the way that it understands the EU law, including the principle of loyal cooperation, and the way that the European Court of Justice understands this, is in contradiction with the Polish Constitution. It doesn't mean, it's not saying that it has closed the door to the supremacy of the European law. And it says that this is related to the interpretation of the law by the European Court of Justice. So that's the first part. So it's not saying that it rejects the supremacy of the EU law over the Polish law. This is the second item. relating to Article 19, paragraph 1, the second subparagraph. This relates to the article relating to legal protection in the areas subject to the EU law. The language here does not refer anymore to interpretation by the European Court of Justice. It only says that it is in the cases of the legal protection of the areas. So in these cases, it lets them not take into account the constitution. And this is an item that the Polish Constitutional Court does not accept. And this might be the most problematic part of the ruling. Because in this article, it excludes, rejects the supremacy of the EU law. What is the idea behind this statement? It says that the judicial system and its organization are subject to the national states. Article 19, paragraph 1, subparagraph 2, only defines a certain level of legal protection in the area subject to the EU law. The problem is, however, that organization of the judicial power is a monopoly, because you can't separate the part of the judicial system relating to the areas subject to the EU law from the parts that are not subject to the EU law. That is why the organization of the judicial system is only one. And the European Union, when it imposes requirements in the areas subject to the EU law, and it also imposes requirements on organization of the judicial powers. The delimitation of the border between these areas that are subject to the EU law and those that are not subject to the EU law is complicated. And this issue is very problematic for the Polish Constitutional Court. And the court rules that that Poland should be able to organize its judicial power internally, not subject to the EU law. And this is the third item of the ruling. And its purpose is very straightforward. The purpose is that the judges do not decide in the areas pertaining to the appointment of judges. They should not decide whether judges were appointed in line with the law, whether this is in line with the constitution. So the third part of the ruling is only a disciplinary one. It has a disciplinary character in relation to judges. When I look at the ruling as a person without any emotional ties in the dispute, and I'm not emotionally involved in this conflict because I'm a foreigner, I do have some political preferences, but it's not the same emotions as the other Polish people have. It always seemed to me strange that there is a debate about judges of general courts and that they could challenge legality of the appointment of other courts. I always thought that the appointment of judges is valid unless a certain condition is fulfilled. So the control of the legality of appointment of judges was supposed to be one of the tools allowing the judges to challenge all the changes relating to the Constitutional Court and the Supreme Court and the general reform of the judicial system. So the third part has a purpose for the future. So the Polish judges should not discuss or challenge these changes of the judicial system. How much time do I have? Well, I would like to ask you to conclude your presentation. Well, the ruling is mainly a political signal. When I first read the ruling, I said to myself, okay, that will really provoke a scandal in Brussels. And I remembered an answer of the European Court of Justice in case Lantova. I'm not sure whether you know what I'm talking about, but this related to the Slovak pension benefits, and the Slovak court addressed the European Court of Justice in order to explain its opinion on this ruling. And the European Court of Justice provided a rather arrogant answer. It claimed that it would not provide any communication to third parties that are not subject to the proceedings. And I think this is not respectful towards the member states. And I think that that is why the response is so significant, and it may even go beyond certain principles. And this might also be the reason why the Polish Constitutional Court provided this ruling.
Now I would like to welcome Ms. Vera Jourova, the Vice Chair of the European Commission, and now I would like to hand over to her and ask her for her opening speech. Hello, ladies and gentlemen. Please let me thank you, the Institute, and namely Dr. Svoboda and Mr. Schmiedek, for organizing this very useful discussion. Thank you for the invitation. So how much time do I have so that I do not exceed the limit? Approximately 10 minutes. Okay, so I will try to go through it very quickly. Ladies and gentlemen, today we've been talking here about the principles of the rule of law and about the basic values that are enshrined in Article 2 of the Treaty on the European Union. These principles are human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. Despite the fact that we are agreed that the EU is not only a single market, that it is also a union of values, this Article 2 must be taken very seriously, and we also insist that these values must really be applied at the same time commonly, otherwise the whole as such would not be all right. The principle of the rule of law is really the backbone, the cornerstone of the European Union. And the elasticity, the flexibility of this backbone is not indefinite. Right now, a discussion is going on concerning how these principles of the rule of law should be observed in individual member states. In order to take a good stock taking of the rule of law in the individual countries, we introduced a new discipline, and twice we have got a picture of 27 absolutely different systems which emerge from the legal traditions, from the history, and from a broad setting of constitutional institutions. According to our opinion, these systems should be based on the same principles, and that is what we discuss with. This is what we also discussed with Poland. I wanted to immediately join in when Mrs. Planyavova was speaking. For the European Commission, it is a new urgent topic, which started with the Polish reform of the justice in December 2015, when we just had to exit our naive bubble in which we lived, meaning that the rule of law is something like a perpetuum mobile, which will survive forever and does not need any special protection. I can confirm that it is really quite that we have a lot to do now in Brussels and Strasbourg after the ruling of the Polish Constitutional Court. As the Commission, we really consider it as a non-political topic which must be devoid of ideology. Whether the government is conservative or liberal, it is mighty enough to set up a system which will fully observe the standards of the rule of law. I do not want to repeat the standards and principles due to the lack of time, but I will rather now comment on topics which you will probably not find in the media, so I may offer a private reflection on this, because it is a topic I deal with on a day-to-day basis. Since 2015, when the reform was started, I've almost said 1215. I think that was a tongue of slip, and I think that was the year when Magna Charta was executed. But since 2015, we have had a hard time in the Commission persuading that these foreboding signals that these signals of the erosion of the rule of law in Poland cannot be restored in the Commission, because it simply is a matter of the sovereign member states, and I really very much honor the limits which we should not cross. On the one hand, we are criticized for doing little and criticized by others for doing too much. And this was also now elaborated on by Jana Planyavova, who said that the organization of the justice system is within the competency of the member states. The Commission has been urging the member states to digitize the justice system and to reform it, but at the same time, any reform projected must always realize that specific standards must be observed, standards of a non-political justice, so that we do not engage politics in the appointment or withdrawal of individual judges. After the awakening, when we realized that the rule of law cannot protect itself, we started work in some three main streams. One is the support of the culture and stability of the rule of law. This is really an ongoing discussion at various meetings of the Council, and also it's been discussed with the public. The second pillar is the prevention of the rule of law before these problems emerge in a member state, so that we can enter into a dialogue as soon as possible. And once serious problems are on the agenda, or once serious problems emerge, it is almost too late for a discussion. We have twice issued the report on the rule of law, one in July and one in September 2020. We want to have a very clear methodology on the collection of data, and we want the process to be absolutely transparent because it is a very, very sensitive topic. And the report on the rule of law has been published because of Poland and Hungary, despite the fact that these two countries have been criticizing us that we've been focusing on these two only and disregarding others. But we will continue this activity and will also formulate recommendations. And the third pillar is the ability to mount an effective response when a problem of sufficient significance has been identified in a member state. I will now skip what you can find in the report on the Czech Republic. You probably know that we cover 4 areas: the quality of the justice system, the anti-corruption measures, and also the media freedom, and also the institutional checks and balances. So if you allow me to, I will simply say that some risks have been identified for the Czech Republic, but generally the findings are quite favorable for the Czech Republic. So I will now skip this part. If some of you want to refer to this in the discussion, I'm fully available. So this is the report on the rule of law. Another preventive tool is the so-called European semester. It's been taking place for a longer time. It in fact evaluates the economy, the economic condition. I wanted the justice system to be considered too because the businessmen and entrepreneurs have been telling us for a long time that the quality of the justice system has been very important for them when deciding whether or not to enter a new market. So our European semester investigates this as well. These recommendations as regards the justice system that we review in the European semester and summarize in the recommendations for the individual member states, we now really want to enforce them, especially when the national recovery plans are adopted. We force the individual countries to follow these recommendations. For example, when leading negotiations with Poland and Hungary, we've been pointing them to these recommendations. We've been telling them that these recommendations must be observed first, and only then they will be qualified to receive these subsidies. For the Czech Republic, we adopted this recovery plan with a condition that the systemic clash of interest must be sorted out. The first Deputy Minister, Mr. Smolak, also talked here about the conditionality regime. It is a very controversial topic, especially when the budget was adopted half a year ago. Since January the 1st, 2021, this directive has been fully effective and it can be fully used. I will now describe how it can work. The European Union shall assess the individual member states, and it shall very precisely define if the findings identified within the justice system, anti-corruption policies, are serious enough, so serious that the funds of European taxpayers would be at risk in the country. So first we must identify the problems, and then we must think of the necessity to protect the finance, and we must also just define the causal connection between the protection of money and the problems in the rule of law. We are now conducting this assessment to apply the conditionality. You know that we've been under great pressure exerted by the European Parliament. I want this assessment to win in a potential legal proceedings, because once we initiate this, I assume that the individual member states will try to defend themselves. But the individual states have also different ways, extrajudicial possibilities. For example, they can refute the statements of the European Commission. Then the leaders can discuss it in the meeting of the European Council, and then the European Commission should decide with a qualified majority and say if it believes that there is a systemic breach of the rule of law principles, that the public EU funds would be jeopardized in that country. It shall not imply that the sanction would freeze all funds possible. We'll always need to apply the principle of appropriateness. We must always regard the final beneficiaries, and that is why we defined very clearly how the appropriateness could be defined with regard to the sanction. Just for the sake of completeness, it would not be for the first time when the money streams would be stopped. I was the Minister of Regional Development in 2014, where we had to catch up with the freezes on payments from the European Commission because of the problems in the audit system. And we are now at a level higher when we when we look at the protection of EU funds. I always repeat that it is a new instrument, but this tradition of suspending the payments has been around for quite some time. Just an anecdote, I dare to say that if Poland or Hungary had also joined the European General Prosecutor system, then there would not be this conditionality. However, Poland got approximately 85 billion euros in the last budgetary period. Then it is really a surprise to me if such a country does not want to follow the will of the whole, that there should be a European General Prosecutor. Ms. Jourova, thank you for the opening speech. I need to apologize to you for interrupting you, and now I would like to move on to the discussion. I would also have a question for you. You mentioned here Poland and also the suspension of the European funds within the national recovery or within the recovery plan. Then you also mentioned the new mechanism which links the rule of law with the money from the European budget. The European Parliament has been making pressure on you, on the European Commission, and it has also urged you to apply this mechanism and to suspend the adoption of the National Recovery Plan for Poland. So which steps are you now considering? I did not mention here Poland because of the suspension of the payments. We assess several countries where we also see some risks. So I would like to know that I did not mention Poland. We are under pressure exerted by the European Parliament, so you can see that when I get excited, the light goes on in my office, but I'm still quiet and peaceful. But I need to correct you a bit. The European Parliament wants to apply the principle of appropriateness as quickly as possible with regard to some countries, especially with regard to Poland and Hungary. As we heard yesterday in the European Council, and the leaders are a bit reserved, and the pressure exerted by the European Parliament is much greater than that exerted by the European Council. The European Commission will initiate this mode of conditionality as soon as the problems in specific member states have been identified, and as soon as we know that we are really on a safe playing ground.
Děkuji moc za tu odpověď.
Thanks a lot for this answer, and I'm sorry for my mistaken question. I thought that the European Parliament wanted the assessment in relation to Poland, but you only talked about the National Recovery Plan. Let us now move on in this area, and let's perhaps go back to the ruling of the Polish Constitutional Court. Mrs. Plaňavová, you said that you have no specific emotions when talking about this ruling, but if you look at it from above, would it be similar to the rulings of other constitutional courts in other countries? Poland claims that also the German Constitutional Court provided similar arguments. So is it similar? Is it comparable? Well, it depends whether you look at it from the political perspective or from the perspective of the rule of law. From the political perspective, of course, there is a clear doctrine, ura vires. So there is this no revolutionary ruling, but it is rather innovative in relation to judges, because it wants to maintain discipline of the judges. This is passed so that the judges don't challenge whether other judges were appointed according to law. But if you look at it from the perspective of the rule of law, it's not similar, of course, because all of the other rulings of constitutional courts decided on matters that were very specific, but this is rather a political message to the institutions of the European Union, and I perceive it like this. As has been said in the first panel, there have been similar radical situations in the EU. You can remember, for example, the case Solange, Handelsgesellschaft. This was also a huge revolution. And what was the impact? What was the effect of this case? Well, now we have the Fundamental Charter of Rights of the European Union. This means that radical and unpleasant political situations can also evolve into something beneficial. But for this, we need general discussion, and we must think about what it really means, what the requirements of the other party are. And we must try to find a constructive solution. I have one piece of information that is important for Mrs. Jourová. Yesterday, there were results of the opinion polls published in Poland, and 90% of respondents want to remain in the European Union, and most of them also think that that Poland should transpose the decision of the EU in the area of justice, and there are 54% who oppose this, and there is a large group of 21% of respondents who don't have any clear opinion. So there is still fewer people who want to conform to the decisions of the European Union than those who oppose it. Let me also say that based on the results of this opinion poll, 49% of people in Poland think that suspending the decision-making regarding the National Recovery Plan is unacceptable. So most people in Poland oppose the conditionality principle here. Okay, well, thanks a lot for this fresh information regarding the opinion poll in Poland. Thanks a lot. Mr. Smolek, Mrs. Planyavova mentioned some dramatic situations which evolved into positive and important effects on the functioning of the European Union and its system. Mr. Smolek, do you think that this might be yet another such radical dramatic situation? Well, I would like to say yes, but I can't see it there. Just like others, we will have to wait for the interpretation of this ruling. Because if you look just at the wording, you can interpret it in a number of ways. For example, Mrs. Planyavova emphasized the part of sentence saying the way it is interpreted by the European Court of Justice. This reminds me of the fact that apart from the legislation as such, you have the interpretation by the European Court of Justice. And there are other three situations which have a general purpose, and they just enumerate three types of situations. And then if they happen, then what is going to be done? That's my question. Because in these cases, the EU law would not have to be applied. And contrary to the rulings of other constitutional courts, such as the German one, I lack any link to the commitment of Poland that would show the commitment within the European Union. It doesn't have to be there, of course. But it is just about the argumentation of the Polish courts. The impression that I have is that Poland is a member state of the European Union. It has certain commitments and responsibilities. And the Constitutional Court just says that in future, if there are situations A, B, C, they should not apply the EU law. And the question is, who initiated this proceeding? And I can see a parallel with David Cameron and his referendum that was compared to playing with matches. And Mateusz Morawiecki is in a similar situation, and the main motive was probably not to know the truth about alignment of the EU law and the Polish law, but perhaps the main motive was to resolve any internal political disputes. And the more member states there are in the European Union, the more political disputes there will be. Because we can see it many times when there is a political dispute between the parties in certain member states. They use this system to erode the EU environment. When the ruling of the Federal Constitutional Court was passed, my first reaction was this can be misused. Well, it seemed to me that the interpretation that by the European Central Bank was important, but the attitude of the European Constitutional Court was either too liberal or too strict. But what they said that they can't apply the norm. In case Holubec, which followed up on case Lantová, there were just a few sentences about the European Court of Justice. Maybe it was not very fortunate to return the ruling back to the court. But anyway, the ruling of the European Court of Justice was followed because it allowed the Constitutional Court to apply its solution. So there was no contradiction with the case law of the European Court of Justice, but this ruling may bring a potential of conflicts in future. We can't foresee what the impact might be in future. Okay, thanks a lot. There has been one parallel to David Cameron. So Britain was mentioned, Great Britain was mentioned, and we also heard about erosion. With regard to the ruling and the Polish context, we heard about the Polexit. So would it be legal Polexit, or are we going forward to Polexit? So, Mr. Dostal, what is your impression? What do you think? Can we face Polexit? Would Poland also leave the European Union? And we have to take into account the opinion polls because the Polish people are very positive as regards their membership in the EU. So should we actually talk about Polexit at all? Well, let's look at the figures as regards the support to Polish membership in the EU, because this figure remains constant. And I'm not sure whether Mrs. Planiavova will agree with me, but based on my experience with Polish mentality, any European integration project without Poland is unacceptable. Well, for them, something that would form the European Union without Poland would be incomplete. It's an element of the national pride. It's an element, part of the national ambition. It's very different from the Czech mentality, from the British mentality, because the British people didn't feel to be such a major part of the European project. And that is why I cannot imagine that if there is a potential referendum on membership in the EU, that the Polish would vote for anything else than staying in the EU. Well, I would have more concerns about a referendum held in this regard in the Czech Republic. The situation in Poland is linked to a political polarization, and it can lead us to a dangerous trajectory. As I said in my introductory presentation, the right-wing parties fight over succession after Mr. Kaczynski. And now is the time when the winner will emerge. And a part of the part that will be important will also be the communication with the European Union. And I think that Mateusz Morawiecki may be too radical. I think that Mateusz Morawiecki may be concerned whether he would be the successor. With all these economic problems that we are facing, the maneuvering space for Mr. Morawiecki will be even narrower. So I'm concerned that this radical wing within the right in Poland will probably be problematic. So the question is whether he will actually win the elections. Thank you very much, and I will now open the floor to the audience. As I mentioned already, and I will repeat it for those who have joined us later. You can raise your hand. You can also speak in English if you speak English, and I'll pass you the microphone and you can ask your questions.
Good afternoon, my name is Denik Skalka, I'm from Ostrava. I have a question to Jana Planiavova. I guess that the greatest problem in Poland is Mr. Kaczynski. Mr. Kaczynski, who has not come to terms with the death of his brother. He accuses almost everybody. And he also says that even, in fact, girls must even deliver a dead baby. So this is in fact who rules in Poland, and what will happen when Kaczynski is gone from politics. I can see that Mr. Dostal is really very much following the situation in Poland, and what will happen when Kaczynski is no longer active in politics, because Solidarność is really just Mr. Kaczynski, who has not come to terms with the death of his brother. He accuses everybody, simply everybody, including the EU. Well, probably you are right in a way. On the other way, I must also admit that despite the fact that this is not my political preference, I must say that there is something that I also see clearly in him. He's an excellent, a great strategist in terms of politics. As soon as he's no longer engaged actively in politics, as soon as he's no longer active on the political scene, and as soon as the contest for his succession will break out, then I can imagine that the situation might become easier for the European Commission, for the European Union, and Ms. Jourova, the Vice President of the Commission, because his successors will not be as idealistic as he is. Jarosław Kaczynski is undoubtedly a person who just promotes and lives an idea. He is not a person doing it out of his benefit or doing something just for himself. In his own political career, he has always done everything to enter the history, simply to be as well known as Piłsudski, for example. So after Mr. Kaczynski becomes politically retired, the situation may stabilize and normalize again afterwards, because none of his successors will be able to fulfill the basic function of a messiah, of a new messiah who wants to savior, who wants to make Poland visible, and he wants to expand the power, the strength of Poland. If you do not know this yet, Poland feels to be a local superpower. So I'm not from the Ministry of Foreign Affairs, but I think that the colleagues in the Ministry of Foreign Affairs know how Poland sees itself. I wanted to add two minor notes. Jarosław Kaczynski is not an unlimited ruler of the Polish United Right parties. It is very often believed that what he says and wants is also done, but there are various factions within this coalition who really do not follow him. and it also has to do with the successor coming to power after Mr. Kaczynski. Well, who will be the political power, or who will have the political power after Mr. Kaczynski? He has a great dream. He simply wants to overcome the post-communist era in Poland, as he defined this. That is the Poland that he dreams of. But he needs a constitutional majority for this, but he did not get it. And that is why he also undertakes some steps even without having the constitutional majority. But should the power be passed over quickly, then a chaos would break out, because the demise of Mr. Kaczynski, his political retirement, would be like the death of Alexander the Great in the ancient times. So do we have other questions, please, from the auditorium? Thank you. It was really excellent. I would like to respond to the speech by Martin Smolek. I think there is a third option available, that there will be a political change in Poland, and that the rulings of the Constitutional Court will simply be declared contra lega. So it is also a realistic scenario. So the improvement in Poland is also not only technically but also practically possible. But we have a much greater problem with Hungary. It is a question going to Ms. Jourova. Is there a way to protect the rest of the civic rights, for example, despite the nepotism and corruption system? Paradoxically, those who present themselves as the solution providers for the corruption have in fact established one of the most corrupted system in Europe, because the system in Hungary is in fact really a very nepotic system. And I would like to ask you, would it be a real problem if Poland, for example, exited the EU? Maybe it would help the Czechs even more than the crazy Brexit. Then we would immediately we would immediately stop talking about the Czechs, because the British are now really experiencing a lot of pain after the Brexit, and I think that the Polish are great masters as soon as the experience of pain is concerned. Mrs. Commissioner, your microphone is muted. Mr. Přibaň has always been I have also perceived him as a very nice person. Would it be tragedy if Poland exited the EU? Well, I am really convinced that Poland belongs to Europe. I've been to Polish, and I also delivered a speech partially in Polish, and I must rather tell you that I'm afraid of an passive Poland that has been really bringing uncertainty to other member states in Europe, because then Poland might do what Mr. Morawiecki said in Strasbourg. We want to shape Europe, that is what he said, but he's shaking Europe now and not shaping it. So Poland is now really shaking Europe, and we also heard it in the European Parliament. A couple of days there was a discussion which was quite different from those before on Poland, because this time it was more about solidarity and about coherence, about a gap that is now widening between Europe and Poland. We definitely want to have Poland in the EU, a strong Poland that would be also our ally. I can remember Visegrad really from the most famous days when Poland played the role of a regional superpower and played it really well. So now to Hungary. Well, the Commission has some tools and applies these tools. The problems in Hungary are manifested in a different way. The Polish people always come with a big bang and then various measures have to be adopted. But when you take a look at Hungary, it is just a range of minor steps leading to the erosion of a democratic system, to the dismantling of the rule of law. And we must respond with those tools that we have at hand. I think that Hungary is quite frightened by the fact that we simply suspended the means, or for example, because we have information that the EU funds are not really well used and protected in Hungary. And I might also respond to Mr. Przybań, who said that the Constitutional Court in Poland might change its opinion after the elections. It may happen, but what I care about is what will happen with those 800 judges that were appointed. That were appointed in a way that we very much have doubts about. 800 out of 10,000 judges. I have a close eye on the situation, and if a new government took office, then this would be really one of the fundamental questions to deal with. So, a very brief response. Well, I have another piece of bad news from Ms. Jourova. A large reform of the general courts is now being prepared in Poland. All judges in Poland will be reappointed. So even if anything changes after the elections, it will be very, very difficult to distinguish who was appointed in which way and at what moment. So that is really bad news. I know about it. So we are really expecting which further steps will be taken. So you also delivered some bad news, and now finally I will read out a question that was posted online. The question goes to Mr. Smolek. Our spectator says that, at least the spectator asks the following: isn't this a principal problem if the constitution of the member state enjoys priority over the EU? So it might be a logical consequence of the fact that the EU is just a union association of sovereign countries. So if there is no breach, if there were no breach of constitution here, all the problems would be sorted out. And the spectator is wondering why the constitution of each country does not always have supremacy. This question is being discussed, and it has been sorted out. I think it was sorted out in 1963 and 1964 when two basic decisions were taken, and I realized the importance of this in 2013 when 60 years of one of the first ruling was celebrated. It was the ruling on Vangen en Loos. That is a complicated Dutch law, Dutch name. It is a ruling on a company which does not exist anymore. It also had a direct effect. Went 1 year later, and there was one more ruling in the Costa case. And the primacy of the communitary law was really once again confirmed. And then a milk control said that the EU law has supremacy over the other laws, and it must also enjoy priority over the constitutional systems of the individual countries. And if this did not apply, then there would be no union law, because if everybody could adopt any law and call it constitution, and that simply cannot be changed, and then we would have 27 different rules of order, so legal orders. So that is why the supremacy over the constitution is just a legal consequence. If we play on one single playing field, is different from playing on 27 different playgrounds. For many constitutional courts, it is quite unpleasant, I understand it, but without this principle it would not work. Thank you for the clarification, for the answer, and now I would like to conclude this panel because the time's over. So I would like to invite you to the coffee break, and let us meet here for the third panel at 2:30, so in a couple of minutes.
Ještě mi... Dovolte mi prosím ještě narušit vaši pauzu. Chtěla bych vás rovněž vyzvat, abyste navštívili opět salonek po mé pravici, kde je nachystáno malé občerstvení, takže si můžete ke kávě dát i občerstvení. Děkuju.
to jsem nevěděla, vidíte, to je zajímavé. Jasně. Je pravda, že to je taková jako ústavně právní dvojice. Já vím. Super, máme taky radost. To je opravdu jako i dobrá jako atmosféra a ta témata tahnou, takže jako my z pohledu organizátorů jsme velice spokojeni, tak doufáme, že nedostaneme zpětně nějaký negativní feedback. Nás tež, protože my jsme chtěli, aby ten panel, nebo obecně, aby ty panely byly takové jako různorodé, aby přesně to nebylo jenom jako pohled právníka, nebo jo, takže i přesně jako jsme rádi, že tady máme pana Buštíka a bylo to takové jako namíchané, tak. Prezentace nemáte připravené? Ne. Skvěle, děkuji.
Tak ještě jednou dobrý den pro nově příchozí. Za malou chvíli zahájíme.
For those who have joined us now, please come back to the hall and we are going to start in a while.
Jdu na to. Jo.
Když začneme, tak si je můžeme říkat.
Tak, už jsme kompletní i tady na pódiu. Dovolte mi tady v tuto chvíli zahájit třetí panel, který...
Let me now start the third panel that will focus on the rule of law in the context of the pandemic and its control in the Czech Republic. It is a pleasure for me to welcome Martin Buchtík, a sociologist, director of the STEM Empirical Research Center. Hello. I also welcome Marek Výborný, member of the Constitutional Committee of the Chamber of the Deputies of the Parliament of the Czech Republic. Within the previous term of office and re-elected deputy within the Christian Democratic Union. Hello. I would also like to welcome Andrea Procházková, editor of the Respect Weekly magazine. Hello. And last but not least, Jan Kysela, who is from the Department of Political and Social Sciences of the Faculty of Law from the Charles University in Prague. Hello. I will now give space to your introductory presentations. First of all, Jan Kysela. So the floor is yours. Thank you. I haven't prepared a speech. I have only made several notes, which probably summarize what you already know, but for the sake of the introductory words, this might be enough. If the key question is how the rule of law was fulfilled during the pandemic and what it meant for the functioning of our country, then I would say that the pandemic showed how our legislation as well as the public administration are ready for the pandemic. It appeared that they were most fixed to the previous battles, to the previous fights. We are effective in fighting floods because there were floods in the Czech Republic. We can fight a tornado, but we can't control the pandemic because we have had no previous experience of the pandemic. And we will see what this experience will mean for our future readiness for any future pandemics. As for the legal order or the legislation, we had no system of specific measures, be it the measures issued by the government or by the Ministry of Health. This is related to judicial reviews, because if you don't know what the act is, then you don't know who might appeal against this act. This is also an inconvenience for the courts, because there is no standard in legislation, and the courts must ask these questions and then decide these conflicts or disputes. And that's why the processes may be quite lengthy. The response of the public administration bodies was involved by the person of the Prime Minister. We know that politics influence everything. And there may be a certain institutionalized framework, but it always depends who will be appointed to the relevant positions. And the Prime Minister then was Andrej Babiš. And he is very prone to micromanagement. But this is not ideal for controlling a pandemic, because you have to respond very fast to many minor issues. And this means that one person to tackle this is not enough. So this was a significant element influencing our readiness for the pandemic. So if this all depends on the person of the Prime Minister, then the situation might be very bad as well in future. What was also omitted was consultation of the measures with regulatory bodies. Especially if special measures were announced by the Ministry of Health, they should have been consulted or reviewed. At the beginning of the pandemic, I think that what would be appreciated would be a large group of specialists, including sociologists, including Martin Buchtig, who would say what you need to handle and control the pandemic, what the legislation offers, what it cannot offer as well, if you don't want to go beyond the rule of law and use procedures used in China or elsewhere. These specialists would also consider the costs to know whether the costs will not be excessive compared to the benefits, and they would also discuss what will be communicated to the public. If you think that everything is all right, you will probably not persuade anyone about the need for restrictive measures. The Legislative Council of the government was included only in during 2020, and if I'm not mistaken, it did not advise the Ministry of Health regarding the special measures. There were some special councils, the general staff, and it was absolutely unclear what were the responsibilities of all these players. I could see how the MESES group worked, and this was only an opportunity of short-term participation, and I did not understand at all how the Ministry of Health works. And this is not an ideal situation, of course. The preparation of some of the measures was limited by the lack of agreement among specialists. And also there were many personal conflicts among the specialists. I come from an area where not everyone likes each other, be it at the university environment or the department at the Charles University. But I was surprised to see so many personal conflicts among doctors, because all this is reflected into agreements or disagreements over many issues. And there were many working groups within the Ministry of Health, and they were positions held by many people with the personal conflicts. And there were proponents of face masks and opponents of face masks, and there may be various epidemiologists and so on. And this then leads to mistrust of the public towards the specialists. The public watches television, of course, it watches various channels. And if there is a specialist who gives a certain opinion, and the opinion is absolutely different from the opinion of another expert, then again, this provokes mistrust of the public. So there was a high degree of disagreement among specialists. Then the government should know which experts to rely on. And there was a large extent of political disagreement. There were some deputies who said there is no pandemic. Then there was another part of the deputies who said, okay, there is a pandemic, but we should choose targeted solutions, targeted measures. And then the rest of the deputies opted for widespread measures. And this created a complicated environment. And on top of that, you had a prime minister who was reluctant to discuss these issues with anyone. And if you need to reach a compromise, and the prime minister is Andrej Babiš, then the result cannot be ideal. As for the disagreement about among politicians and among experts, well, the measures should be adopted by the executive powers. Other countries adopted the pandemic laws, while we adopted no law, and we tried to adopt all measures based on the Public Health Act or the Crisis Act. And only in the next wave of the pandemic, we adopted the Public Health Act or the Pandemic Act. But again, it was influenced by many opinions. So it depends what will you actually write in the act. If you think that certain restrictions are unacceptable, they will not appear in the act. Well, it seems that you are taking the microphone and that I should conclude my presentation. So let me mention the courts. From the perspective of the Constitutional Court, I can be brief because the Constitutional Court was quite inactive, and it only issued some exceptional opinions. This was because the Constitutional Court would be active in the area of crisis interventions of the government. But what we issued were mainly acts passed or measures passed by the Ministry of Health. So these were boundary situations that might be in future reviewed by the Constitutional Court. The whole agenda of the judicial review was given to the appropriate courts, and in the first part of the pandemic, the courts didn't give us many rulings. This was due to the fact of our manner of regulation, because if you adopt a measure and then you abolish the measure and someone appeals against the measures, then the court must suspend the measures because the merit of the case was annulled. And this made it impossible for the courts to give a ruling regarding the measures adopted by the Ministry of Health. At the end of the first part of the pandemic, one of the municipal courts gave a ruling, so we received one of the opinions, and the next rulings came only after the adoption of the Pandemic Act. So what we should consider is the constitutional approach and the legislation that we want to adopt. And I don't know whether the Senate should not participate also in the adoption of such laws. And we should also consider the opportunities for judicial review, because if you have a crisis, you can't prepare the acts so thoroughly as in other times. So you need to be very clear about what to include and what should not be included. And we should consider the structure of organization, who should do what. And if possible, those who act should be communicating towards the public in an empathic way. Because without empathy, without understanding the impact on the others' lives, because we want you to keep your life, to be able to maintain your life. So without this type of communication, the consideration about standards and institutions will not make any sense, because you won't get any understanding population.
Já vám moc děkuji.
Thanks a lot for the opening words and also for speeding it up a bit. The more space we have for discussion, all the better. Before I hand over, I would like to remind you once again of the fact that you can ask questions, even though you follow us online. So if you follow us online, you can just drop the question in the chat below the broadcast. And now I would like to hand over to Martin Buchtig and ask him for the opening speech. Hello, I will start with a broad concept. At the very beginning, I would like to talk about the basic perception of the judicial system in the Czech Republic, how it is perceived by the public at large, because it then provides a good framework for the remaining discussion about how it has been in the past 1.5 years. The rule of law is perceived quite positively when we look at it from the perspective of institutions, despite the fact that the people do not distinguish between the individual types of courts, and despite the fact that people are not clear about this, because they do not know exactly what the difference is between the prosecutors and judges, and what the role the policemen play in judicial proceedings. In this respect, the institutional layer is perceived really very positively. Some 65 to 70% of the public at large perceive the Constitutional Court positively. It may seem to be little, but among the Czech institutions it is really in fact the highest value. So when we communicate with some institutions, we tell them you might one day be as respected and as popular as the Constitutional Court. When a government is popular, then it has a rating of some 40%, and the president. So it's really fluctuated in the case of President Zeman, but the max was 55%, and the Senate enjoys a trust of about 35%, and the same applies to the lower chamber of the parliament. But some 15 or 20 years ago, the trust into the members of the parliament in the lower chamber was just about 20% some time ago. So if the people do not believe that the democratic system does not make sense, and if the people do not have trust in this, and if they believe that their voice won't be heard, then they find it quite improbable that they would prefer the rule of law. This is really very important to realize that you cannot increase the trust into the justice if you do not increase the trust into the society as such. And you must also see some future for yourselves and for your children and grandchildren. And if you do not see any future for yourselves and for your next generation, and if you believe that the failure is really just heralded from one generation to another, then you won't believe in some such constitutional systems. And the judicial system is very often associated with politics. When we see that various decrees issued by the Ministry of Health are revoked, and it only causes chaos. But we must say that during the pandemic, most people rather acted intuitively. They rather followed the people around them to find out which resolution is just valid. At this moment, many measures have been adopted, but they are not observed, and that is why it is quite difficult for the incumbent government to say, sorry, this is really bad, and let us start observing the rules again. So that is why we are struggling another trouble here, and this ambiguity, but it had no real impact on the rule of law, because the people simply could not distinguish between what is a political fight and between some minor delicacies between the lawyers and, for example, the civil servants in some ministries. And the third dimension is also important, and that is the individual rulings of the Constitutional Court, for example, or for example of some cases which are very much which very much attract the public at large. Very often the people project their own opinion onto the institutions. So, for example, if some people like a Prime Minister Babiš, and if suddenly the Prime Minister is, for example, accused, then they say that they have no trust in the rule of law. So the public opinion is shaped really very slowly, unless there is a shock, unless some systemic corruption is, for example, identified in the judicial system. So luckily, the rule of law is quite stable in this respect. If I may say two more things. It is quite important that the Czech public distinguishes the rule of law into several categories. One part of the population lays an emphasis on the efficiency and functioning of the judicial system. And the people do realize that there are many deficiencies to the judicial system. They very much realize that some decisions are issued after years or even after dozens of years by the courts. So in this respect, the people are quite skeptical about the quality of the judicial system. But with the exception of some failures, the rule of law has been around, exists. It may seem to be a trivial finding, but for example in Slovakia, the trust, the confidence in the rule of law is significantly lower. It is quite understandable if you follow the situation there or in some other countries of the Visegrad 4 group. We must also state that very few people very few people are concerned with the rule of law who are really doing very, very well, and it goes well beyond the regular problems. The rule of law as an idea will never win your elections because max 20% of people will be interested in this. For example, 25% of the people will be interested in what is going on in Poland, but it will also be closely connected with your preference for Poland's or dislike for Poland's. The rule of law is rather understood as important by the public when there is a clash or accordance with what you are interested in. For example, if you, for example, see a clash with the opinions of your favorite politician, we may state that if the confidence in the rule of law starts declining in the Czech Republic, especially abruptly, then it is quite probable that we will be very close to some major unrest and upheaval in the Czech society. So the rule of law is the last thing that the people will stop believing in, and there's not much confidence in the rule of law. Well, thank you for the introduction into the public opinion and into the positions of the public at large. I noticed that some people in the auditorium already raised their hands. I just wanted to announce that once the opening speeches have been delivered, I will hand over to you. Now I would like to hand over to Marek Výborný and ask him for his opening statement. Thank you for the floor. Thank you for the invitation, ladies and gentlemen. Maybe I will now follow up on Professor Kysela, who said really everything significant, but I would now like to quote from the reasoning of a ruling of the municipal court here in Prague. The fundamental rights must be granted even in a state of emergency, and they can only be restricted in a foreseeable manner. So this is a very short quote, a short citation at the very beginning, and I think it very much indicates what the answer will be to the question how the rule of law fared during the pandemic. I think we can also use the reference to a half full or half empty glass of water, because on the one hand we saw what has been described by the colleagues. On the one hand, very chaotic measures were adopted. First, the measures were adopted by the government, then by the Ministry of Health, and then again by the government. But the rule of law, in fact, turned out to be functioning because the courts, in fact, exercised the control function, even though it took some time. In the second phase, the courts were able to assess the restrictions, and very often the restrictions were also revoked. But it also points to the second large problem, which can be observed in the executive and legislative power. So, unfortunately, the situation here is really quite critical. The executive power was not able to adopt measures that would be in line with the legislation. Prior to this conference, I went through the 14 rulings either issued by the Constitutional Court or by the highest Supreme Court, or the highest court in Prague. And every time I found here the reasoning that there was no justification, or that no reasons were given for the adoption of specific measures. And this turned out to be a great problem. The legal situation in the Ministry of Health is really in a very desperate condition. So the courts did not challenge the factuality of the measures. I think that very often the measures were correct in terms of their factual target, but unfortunately the ministry which issued the measures did not give any reasons for it, and this is one of the reasons why we had to adopt the Pandemic Act several times, because we really missed several things in the decision-making of the government or the Ministry of Health. And we wanted to enshrine the specific procedures, including the judicial review. So the judicial review is also enshrined in the Act, despite the wish of the Prime Minister to remove it. And the courts have used this very frequently. So if I conclude this part, I may state that the pandemic has shown that, and I think it is quite important for the new government that is being formed and the new legislators, and I do not only mean the members of the lower but also the members of the higher chamber, upper chamber of the parliament, but we must really revert to the crisis legislation because during the pandemic it has turned out very important. The crisis legislation in the past was drafted for completely different situations that we experienced in the past, but nobody foresaw a pandemic to such an extent. The Public Health Protection Act was designed for this purpose, but unfortunately it has turned out that this Public Health Protection Act cannot be used, especially after the measures were only adopted by the Ministry of Health. This was challenged by the courts, because the courts believed that it is not possible to come with these measures only on behalf of one single person, in this case the Minister of Health. Or very often it was only the first deputy minister, or for example a high-ranking civil servant who adopted some measures, and then we can hardly concentrate so much power in one single person, so much power that can restrict the fundamental rights of humans, citizens. We can't concentrate it in the hands of one single person, be it an executive body or, for example, a civil servant. So these are the controversial points which turned out during the pandemic. I represent here the legislative power and both chambers because we really cooperated very closely during the pandemic. And I think that we may state that this experience has been really quite new for both chambers of the Parliament. When you take a look at the Rules of Procedure, section 99, it describes how the procedures should be conducted in the state of a legislative emergency. This section has turned out to be quite important, especially in situations when crisis legislation had to be adopted very fast. So we are able to use this section 99. On the other hand, it turned out that there were tendencies, especially of the government, tendencies to abuse this section 99. In that case, it is important that the majority in the Parliament, the lower or upper chamber, can really execute the control function and simply indicate that some things must be debated within the legislative emergency procedure, even within a couple of hours. So, for example, on one day we received the drafts, on the second day we debated it, and on the third day we adopted the legislation. I think we experienced this for the last time when Czechoslovakia was split, and when the Czechoslovak crown was separated into the Czech and Slovak crowns at approximately 2 in the morning. So we also voted on the important COVID legislation in the early hours. So the actionability of the Parliament was guaranteed, but we must make sure that these extraordinary actions, like for example state of legislative emergency, are only applied appropriately. So that we do not abuse this.
To conclude, I would like to say that what we have experienced over the past 1.5 or 2 years should be subject to a detailed analysis now. I think this is a great wealth for the faculties of law and for the students and for the academia. Of course, not only the students of the faculty of law, but also of other fields, because they should be able to analyze the evolution of the legislative process. We should try to make the changes that are necessary, especially in the area of the crisis legislation. We cannot say that no similar pandemic will come, and we need to be ready for the event of another pandemic, and for this we need to use both the positive and negative experience, and we should incorporate this in the legislation, of course, when respecting the principle of appropriateness, because there was a legislative state of emergency, so we would like to enjoy the state of legislative well-being and to adopt future legislation with the principle of appropriateness. Thank you very much, and I'm looking forward to the discussion. Thank you. We are approaching the Q&A session, but before that, I will ask Mrs. Andrea Procházková to give us some introductory presentation. Well, the advantage and disadvantage of speaking as last one is that most important things have already been mentioned. So I will try to be brief. When I prepared for this conference, I started to use two quotes. The first one by the former Minister of Health, Petr Arenberger, and I quote, "People must respect our measure until it is abolished by the court. We have already received some interim opinion of the court." He said the medical side of the measure is more important than the legal one. And Andrea Schillerová wanted to adopt a zero VAT and that she said we did this a number of times for the face masks and we were not punished for this. If there is an infringement based on the EU law, before the proceedings is initiated, all of the measures will be gone. That's what Mrs. Schillerová said. And the court ruled that there was a contradiction in the measures adopted by the Ministry of Health. There were 39 of these cases. So the last case was the obligation to test children at summer camps. There were some reasons for this, because the measures went beyond the area of the scope of control. And I can see two issues relating both to citizens and to the judicial system. Let me start with the citizen level, the civic level. Ron Fuller, whom you have already mentioned, as I was told by Mr. Pribáň, Fuller claimed that law must show 8 elements. It should be clear, with no contradiction. It should not require something that is impossible, and it should remain to be stable. Of course, some of these elements are so important according to the Constitutional Court that if these elements are missing, that it contradicts the Constitution. All these 8 elements help us understand the purpose of law as the set of rules that we respect. I always thought that the inner morale of law is a set of rules that help us, the ordinary people, understand why we should actually respect some of the rules. Why should we respect what the state says? However, during the pandemic, the question emerged whether we can require that the citizens fulfill the rules that the people don't understand if the measures are unjustified. The Supreme Administration Court systematically warned that the officials only copied and pasted parts of the measures already adopted, although they knew that the courts dismissed them as insufficiently unjustified. There are 2 explanations to this phenomenon. First of all, a misunderstanding of the rule of law. So this may be a misunderstanding of the rule of law on the side of politicians. Not everyone may understand why we should have a separation of powers, why you should be controlled if you were elected by the people. And the second explanation is clear purpose of writing these bad measures and rules. And that's what politicians also say. Alena Schillerová herself is a lawyer. And it means that these errors were not probably caused by misunderstanding of the legal system. During the pandemic, it seemed that the law was an obstacle to controlling the pandemic. And perhaps it would help the overall situation if the lawyers don't step in the process. And the Supreme Administration Court provided clear definitions of how to write the measures and acts. Liberal democracy is based on the fact that the politicians will not go beyond their competences and that they will not misuse the powers invested in them. This principle should apply especially in states of emergency. As we could hear, a pandemic may be an excuse for our bad legislation, but the pandemic should not be any excuse of acting without regard to law. It should be the other way around. Let's look at how it works in the opposite direction towards those who have the power. For example, taking off the responsibilities of the president. We have been discussing this for many weeks and we are requiring legal analysis. We want an update on the medical condition of the president because we can feel that this is a major intervention. And it's good that we are discussing this. But let's put this into contrast with the pandemic, and we can see that there is not sufficient respect towards the people. Over the past 1.5 years, the freedoms and the rights of people were reduced, and it was said that we required legal cleanliness for no reason. So thank you very much. That's all, and I'm looking forward to the Q&A session. Thank you, Mrs. Procházková, for your introductory words, and I would like to ask you whether there are any questions in the audience. Hello, Julo Kaplan. Thank you for all these presentations. I appreciated them. Could we look at it from the other side? In the Central European countries, including the Czech Republic, there is little legal understanding as far as the ordinary people are concerned. Mr. Kysela mentioned this, and he said that people should be empathic when communicating the measures. But shouldn't the population also be empathic towards these changes, because they should consider their goals, the goals of the society, and the interests of the general public? I think that this is something that we miss in the Czech Republic. The Czech population is also a population of the European Union. And there is a lack of empathy. And it's a problem to put in contradiction the Czech interests and the EU interests, because we are part of the European Union, and the same goes for the Polish and so on. And I hope that the situation will improve in Hungary and in Poland. In the Czech Republic, the situation is a little bit better now, but this does not prevent any deterioration of the situation within some 20 years' time. So thanks a lot, and I hope that all of the speakers can respond to my question. So, lady first. Well, I wanted to not answer this question. Mr. Kysela wanted to respond, actually. Well, I think that I'm obliged to answer this question. This is a complicated question, of course, as you will understand. So I don't know whether we are competent enough to answer this question. I think that the people are highly individualistic, which is a difference, for example, to Scandinavia, because the Scandinavian populations are very cohesive, very collectivist, which can make a pressure on the people, but it can also mean that the people think about others. And I think that we have had an experience of the communist regime, which made the people to think especially about themselves. And there is no motivation to speak to others and cooperate with the others, because if you are just an individual, you are no obstacle for the state. So this certainly plays a role, a significant role in the process. And you can add more layers to this. For the Czechs, the state means the foreign things, not my things, by which I could influence my life and other lives now and in future. There is also a huge mistrust in the political representatives, which is strange because we choose the politicians and then we don't have any confidence in them. And we could add even more such components. And when the state issues regulation, then we think that this doesn't mean anything for me. And even so, when the sense or the purpose of the regulation is not justified, of course, an expert made up with this regulation, but I will find another 5 experts who will say that we should not be vaccinated, we should not wear face masks, and so on. So this is a complicated situation, and I don't know what we can do about it. We can't do anything that would require immediate action. This also requires civic awareness raising, civic education, but this may not be enough. So I assume that my answer has not been very positive, but I can't think about anything else. Let me comment on this briefly. From my perspective, the Czech population can see the rule of law and the certainty of law as something very abstract. And only when we can see a specific threat, a specific person endangering the rule of law, then we can fight. This is something that we could see in the previous months or years. But if there is a lack of this personification, I think that the Czech population wouldn't care at all. So I'm grateful to the judicial power, and the separation of powers seems to be essential here, because this is the check and balance that can put the foot in the door when one of the powers wants to misuse certain situation. And then we heard another term, empathy. Well, I think that we lost the fight for the cooperation between the powers and the population. If you completely change your approach to controlling the pandemic, if you adopt chaotic measures, and if you have no clear strategy based on hard data, if you lack a strategy that is understandable for the population, then you can't expect the population to trust you.
So I think that Mr. Buchtík will give you more information on how the Czech society perceives the rule of law. So when you take a look around Europe, or for example around the United States, there is also a low legal awareness. You don't always need to know what the measures mean, but you must know why the measures were adopted. And if you just identify yourselves with the rules, or for example with the politicians who are just in power, or with some other authorities, then it is quite enough. I think it would be really great to have a high level of legal awareness if for example, 80% of people in the Czech Republic or anywhere else had a high level of legal awareness, but it is quite impossible to request this from the people. I think there is not only one reason from my perspective, and it's very difficult to find one only answer, and if you then promote one single answer, then you are very populistic. I would like to point out some moments, like for example the trust. The trust is very slow and difficult to gain, but it can be lost very quickly. We very often have the feeling that we can, for example, come up with a new agenda and that we will change the society in half a year or in a year, but that will fail because the processes take a long time to establish themselves. For example, if you do not talk about the EU for 10 years and about its importance, then you can't simply expect that a couple of months before the presidency, the public at large will suddenly become awakened and realize the significance of the EU. But it is a failure of the elites. Quite definitely. On the other hand, we had the trust in the Czech Republic. The government enjoyed really a high level of confidence, but unfortunately it lost the government, especially in international comparison. For example, in March 2020, 75 people had trust in the government, and now it was now 25. So we started at the level of Scandinavian countries, and right now we are even below Spain. And in Spain, the confidence in the government is really quite low. So we can't expect the government to be well educated. On the other hand, I have difficulties just hammering a nail into the wall, and the people the people just have some other skills, and if we do not have the trust in the institutions, then it's really bad. Now I would like to ask Mr. Svoboda. Pavel Svoboda, I would like to ask you the following question. It is a question concerning the legislative process. At least it makes the impression as if there were an association with another phenomenon here, as if the government itself were pushing through its own bills via the legislators, via the deputies, which means that it avoids the commenting procedure, the internal commenting procedure, and because they want to make the impression as if the comment procedure were only a matter of delay. So I would like to ask you if it is only a coincidence, even though I see many occurrences of this coincidence recently, or if there is some link with the fact that, for example, there was a lockdown in the ministries and they were not able to operate at full swing either. So this question goes to Marek Výborný, so I would like to ask him if he can in fact give us hope that the new government and the new parliament will not succumb to this infection. Thank you for this question. If you really form the government as it seems to be, I think I can guarantee that we will not act this way. But unfortunately, I'm afraid that what was said here had in fact no association with the pandemic. It was a general condition, a general state. I'm just stating an objective matter, an objective fact. The government was really a minority government, and it had some opposition within itself. We could see it also in various votings. And that was one of the reasons why many government drafts were really why many government bills were in fact presented by the individual deputies, by the individual members of the lower chamber of parliament. And another thing is that the individual ministries unfortunately draft the bills in a very bad quality. I think that the legislators, the lawyers in the individual ministries should be re-educated so that they really know how to draft the legislation. And the bills were not commented on by the Legislative Advisory Board of the government. So that is why the government always wanted to present its own bills via the deputies. It's always bad because in the parliament we do not have the expert background or the legal background, even though in many ministries the lawyers are really at a very bad level. But for example, if we just need to rephrase some important legislation in the parliament, then it's really very bad, especially if it concerns, for example, the Insolvency Act, which was absolutely unusable, and we had to rephrase it in the parliament, and that's bad. It went wrong, and I hope that the new government will not do this. We will try to minimize the bills presented by the individual members of the parliament, because if the legislative process is to be at a high quality, then we must simply draft the legislation where it is to be drafted primarily, and that is in the ministries, and it must also be commented upon by the Legislative Advisory Board of the government. You simply can't circumvent the Legislative Advisory Board of the government. So, for example, if it is rejected 3 times by the Legislative Advisory Board, and then the government parties simply presented the bill via the individual members of the parliament. So I hope that we will not see it in the future again, and I hope that the quality of the legislative process will increase again. But I think this has no direct relation with the pandemic. We noticed several times that the Article 99 of the Rules of Procedure of the Parliament was abused. I can give you one example for many, like, for example, a quick amendment of the insolvency procedure. I don't know if it was said here by Mr. Kissela. The outgoing Prime Minister is very much focused on the micromanagement. A group for example, a group visited the Prime Minister, then he gave a call, and over the weekend the draft of the insolvency procedure and legislation was written over the weekend, and we rejected this, and this is really an example of how it should not work. I'm not a member of parliament, I'm no deputy, but I have a note from the journalistic perspective. I think it is not bad if the members of the parliament come up with their own legislative initiative, but it must really be an exception. Very often there is a discontent in the government. For example, Mrs. Pekarová has now said that she would, for example, simply suggest a draft on the marriage on the same-sex marriage because she knows that the government would not adopt it. So that is why she wants to present it as her own bill. I simply know that this is an exception where it really makes sense that you circumvent the government because the government should also emit a signal as a whole. It should at least convey a direction it wants to act. And one more note, if I'm not mistaken, the Civil Engineering Bill, the Civil Engineering Act, was an act presented by the government, but there was really huge oppression against it. Well, it was voted for by SPD, the Communist Party, and the ANO Party. It was adopted for the third time, but there were many remarks were not incorporated into the text. So you see what respect they have for the Legislative Advisory Board of the government. I myself am not opposed to the bills presented by the individual members of the parliament, but they are here mainly for the opposition because the opposition cannot present it via the government. So in this case it is really fully justified. So and then the majority must simply decide whether or not it will be adopted, whether or not it is presented first by the opposition or coalition. Just a minor note, in 2008 I co-wrote a book about the theory and practice in law. This existed even before Andrej Babiš. And the minister can, for example, put a motion. This is what Andra was talking about, but not only. So we must know the reason why the minister is doing it. Maybe he wants to attract attention, or, for example, he was just refused by the government. And then there is another second type, and that is the bills presented, or motions presented by the individual deputies. But if, for example, it is only presented and drafted by the individual civil servants despite the will of the minister, and then they are no civil servants and they are also pursuing their own politics. I do not want to claim that this would be well spread, but I do not want to say that the government is really producing only the best legislation. But even if the government adopted very good or produced very good legislation, the deputies very often wanted to amend it regardless of the quality of the legislation because they had their own idea, or some lobbyist told them what the bill should look like. Which influenced the quality of the legislative process in the advisory board, because, for example, the Legislative Advisory Board knew that they just drafted a bill and then it was completely amended by the Parliament. And now I would like to move on further, and I would like to quote some questions from the internet. At the very beginning, Mr. Kissler said at the beginning that the limited preparedness of the legal proceedings turned out. And the Spectator says if we are going to prepare the legislation for even greater health risks than COVID-19, which might, for example, come when we have some bacteria resistant against the antibiotics. So maybe I would like to extend this question a bit, and would like to ask if the Pandemic Act really sorted out the problem with the preparedness.
Well, first of all, there is limited effectiveness of the Pandemic Act. So, if I'm not mistaken, at the end of February next year, its effect will terminate, so there will be no longer the Pandemic Act. But the Pandemic Act should have complemented the Public Health Act as well as the Crisis Act. So definitely this is not over. And as Mr. Výborný said, we have to come back to the regulation of these crisis events and situations. We don't need to adopt fundamental changes, but what we need to modify is the Crisis Act and the Public Health Act. And you have to ask yourself a question, for which situations you find appropriate to declare a state of emergency, and whether you should use the Crisis Act. And the Crisis Act should have a specific part saying that if you declare the state of emergency in a state of pandemics, then you should adopt these measures, these specific measures, or that you should use the Public Health Act. But there is a risk mentioned by Mr. Výborný that the Public Health Act is an act intended for the Ministry of Health. And if you fear that there might be certain risks, then it should not be included only in the Public Health Act, or you would have to devise more options. For a minor pandemic, it would be the Minister of Health who would decide, and if it's a major pandemic, then it would be the government that would decide. Thanks a lot for answering this question. If we think about the pandemic at a more general level, and if we look at society, we could see that Czech society was divided as regards wearing face masks, inoculation, vaccination, and so on. And my question to Martin Buchtík is, if we have evidence, hard data about this division within our society, can the pandemic further deteriorate the situation? I'm just trying to illustrate this situation. Or is it just a headline in the media that society is divided? Well, it has been proven that society is fragmented. It's not polarized. It's not divided into two main camps, as we could see, for example, from the headlines in the US. And but I will not elaborate on the situation in the US. So that's one dimension, the fragmentation. The second dimension is that very often the issues are binary. They have a binary character. We have a pluralist society, which is an advantage, I think, because in the 1980s, everyone had the same opinion, and people say that that was not the best situation. If we say that something is black and another thing is white, then it's simplified and it leads to the elections, which will either be yes or no. So this is something similar to the presidential election, where there were two very strong persons and you were to choose one of them. But in most cases, society is not divided into two polarized camps, fighting against each other. And as for the support to certain measures, the camps tend to vary. And there are not only two camps. Of course, the two sides are often the most visible. But in November or in September 2020, the population was quite satisfied with the measures adopted. In autumn, there were 20% of people saying that the measures are insufficient, 30% thought that the measures were excessive. And then after a few months, in March or in April 2021, 30% of people thought that the measures were insufficient, 40% said that they were excessive. And the people that were satisfied were in clear minority. Yes, in that particular situation, we could see polarization of society. And in June, there was no polarization of society because the epidemic was over, we could go on holiday. You all know the story. The society is not divided. There is a fragmentation trend, and this can lead to our inability to decide. And empirical data tend to show that this is a situation in which we can't decide. It seems that polarization of society is more significant, it's more visible, but it's a cognitive trick that is played on us. Okay, thank you. Are there any questions from the audience? Thank you. Kateřina Stehnová. This may be a sociology question, and I'm interested in your expert opinion on the issue, or the civic opinion on the issue. What actually harmed the rule of law during the pandemic? Was it the fact that government adopted unlawful measures, which at least in the first stage of the pandemic, I can't pardon the experts because this was unprecedented situation and we lacked a legislative support here? Or was it more about the fact that the ministries kept repeating the same legal mistakes, although the courts ruled repeatedly that there were errors? As we said, the justification was missing in the measures, and this is what the court said. They repeated that they need justification in the acts, in the pieces of legislation. In the first stage, when someone adopted unlawful measures, I can't see any misuse of the situation because there was no willingness to breach the rule of law. But if they were repeatedly warned by the courts, then this might show a sign of doing it on purpose. So what do you think harms the rule of law more? Which situation? And let me comment on Mr. Buchtík, who spoke about the confidence of the population in the measures adopted. I think we haven't heard yet that our high representatives, our politicians, were to blame for the mistrust, because you should remember Minister of Health Roman Primula and others who met in the restaurants which should have been closed. They were not wearing any face mask. Or Miroslav Kalousek, who was seen with a pint of beer in the street, although it was forbidden to sell the pints of beer even outdoors. Who would like to answer this question? I will start. Well, the rule of law is harmed repeatedly. You concluded by the role of the politicians. If you look at the Czech Republic and how it handled the conflicts of interest or the suspected conflict of interest of our Prime Minister. If you look at our President and his use of the Constitution and the response of the system, everyone appreciated that Mrs. Kaslova won the case, but it took 6 years. So it seems to me that this is a base for the mistrust in the state, because a double standard, if you are rich, you have sufficient power, then everyone behaves differently to you. And this also applies to the office of the president. As I could see, the fastness of adoption of the regulation in 2020, and as I could observe the slow response of the court, and everyone was reluctant to say something because you could cause a death of many people. The judges are alibistic sometimes. So the year 2020 didn't show any strong reflection on what the executive power can do and what cannot do. After the adoption of the Pandemic Act, the government could think that they could go on like that, but then it was not possible any longer. And I'm not sure whether the government or the judges are to blame. And then came the next stage, which you have talked about. This is the situation when the judge repeatedly says this is the wrong way of doing that. If there is a lack of competencies, then you should be looking for the solutions. There is one famous scene which is about looking for competences. Either you have the legal competences or you don't have them. But if you seek for justification, then you don't care about the legal competences. You just have to convince everyone else. And if you have no justification, then you will not convince the others. But if you do have a justification, then what will be the sufficient justification? And if you are on this second track, the government is not just a group of criminals, because it depends on the moment in which the courts will be satisfied with the justification. Let me add one thing. The Pandemic Act is quite strict, because if you look at Great Britain and the justification requirements, the act was written by the politicians. And they needed to consider how strict the regulation should be. So if there is a lack of justification for the courts, that may be the worst case. Because if you are beyond your competences, then it's evident. Sometimes this may happen because you don't really know what your competences are if you are a ministry official. But if the courts keep telling you for 3 months that this should be the justification, that you keep giving them the anonymous reports on the impact of the measures, and if you submit analysis about face masks, so this has led to such a level of frustration of the courts. that I'm not surprised that the Supreme Administration Court said, oh, please start writing the regulations in the right way, because you keep giving us the same wording and you are unwilling to understand what we keep telling you. And this is important for the future relationship between politicians and the judges.
As far as the Pandemic Act is concerned, we must remember the context, because we had the emergency state for a long time, and the Parliament did not have the will to extend the emergency state with all of the powers that the government has in the state of emergency. And at the same time, it was known that we did not want to complicate the management of the health system, because the public health systems at the regional level turned out to be malfunctioning. But that is a topic for a different discussion. And that is why we just attempted to create a soft version of the state of emergency, and that was then incorporated into the Pandemic Act. So don't look for any other reasons behind it. That was the goal that we were pursuing. And it was also being drafted in cooperation with the opposition. Maybe we are more strict, but with regard to those steps which were taken by the government before, which were taken by the Ministry of Health, and we have talked about this today several times. That is why we were more stringent, because it turned out that the government did anything it wanted, regardless of the Pandemic Act. I am afraid that we may overestimate the coexistence or the association of the people and the rule of law and the legal awareness. I think that the elites very much influence how the people act, regardless of who it is. If it is Mr. Kalousek, for example, Mr. Primula. So, for example, if their behavior is then presented by the media, then it is a much worse impact on the people and on the observance of the rules. I think this is a major impact, a larger one than the legal awareness of the people. Everybody used a quote or a legal citation, so I will now quote one. We wanted to do it better, but it ended up like every time. I think this is how the public perceives this. The public did not perceive why the measures were adopted, why they were then cancelled, etc. And the second problem is our attitude to the legal rules. Paradoxically, it is sometimes good if you are just indifferent, if you do not care about it, because you do not care about it as long as it works and as long as you find it really clear and take it for granted, which is in our case the rule of law. Or, for example, you become indifferent at in a situation when the situation is so desperate that you have just resigned and do not vote to protest anymore. And that was the situation when these measures were adopted. The people did not perceive it as a legal act, but as a political act. And it very often was associated with an emotion towards a specific politician. The Czech public does not perceive the politics as a place where their interests are protected, but the Czech public perceive the politics as a soap opera that we need to watch, and every other day new intricacies are presented which are even more absurd, but they are so bizarre that it even is fun towards them. But to end and conclude on a positive note, I hope this is over. Thank you, and now I will hand over to the last speaker from the auditorium. I'm very, very nervous. Jana Mileřová, Populis. I wanted to follow up on what you said before on the topic of trust and on the decision-making of the government, because what we did not touch upon is the role of the citizens. In our organization, we very much deal with the civic participation, because we very much want to engage the non-governmental organizations in the legislative process so that the right legislation is adopted. I wanted to ask Mr. Buchtík how he perceives this, if we can, for example, this way build up the confidence of the public into the government. The public opinion research has shown that the government has next to no power to influence what is going on in the government. But on the other hand, the research shows that the people would like to be engaged in the legislating process. And I would like to ask Mr. Výborný if the government is ready for this, for example, by means of the parliament, because what you described here was in fact only the bottleneck between the parliament and the government, but the civic society must also play a role, like, for example, by providing data or by supporting the meaningfulness of these processes. So this is a more complicated question toward the end. So I would like to ask you for a very brief reaction. The feeling that we can influence something is very much influenced by the socio-economic factors, by the conditions you live in. So it is really very much influenced by your living standard. So, for example, if you have a high social and economic capital, then you have the feeling that you can really influence something across the society and at your own level. Second answer, a general impression is that people just believe, oh, it is a bit embarrassing if you want to engage yourself in politics, and since you were 15, you know that you do not want to be embarrassing. And very often those who act publicly act on a populistic note, and they only present a very radical position, which means that regular people then are not heard, because regular common people very often have the feeling that in an expert discussion they can't voice their opinion, because it is, for example, also a matter of legal arguments, and if I, for example, want to engage myself publicly, then I might ridicule myself. As far as the legislating process is concerned, I do agree with you. We talked here about the COVID legislation, which was drafted within a couple of hours. I now realized that we also adopted a package called COVID justice, and for example, the temporary moratoria on the seizures were very much supported by the NGOs. So the NGOs, the field, provided us with some food for thought, so that we could really very quickly act and incorporate these policies into the new legislation. But it very much depends on who does the preparation of the legislative text. I myself want to say that I always wanted to communicate with all stakeholders across the society, with experts and with NGOs, and it's always good to have really a broad mosaic of opinions, because when you only focus on one single segment, it is not good. If you only speak to those who help the debtors, then you will try to help the debtors only, and then you will also forget that there are also serious and solid creditors. So it's always good to find a balanced solution, and I myself am convinced that it is possible, and I'm saying it out of my own conviction and experience.
Já jsem jenom chtěla říct jednu věc.
I wanted to add one thing. It is key that in the next election period we adopt the Lobbying Act. You don't think so? Well, I think so, because at the European level, the MEPs ask all of the players, all of the stakeholders to the table, and they ask about the form of the regulation. But, you know, different people may have different opinions on the matter. Well, I would like to thank everyone for their comments and questions, and now is the time to conclude the third panel, because our time for this conference is over. We could speak for hours about the rule of law as well as about the pandemic and other issues that have been mentioned. It is a great pleasure for me to thank all of the panelists as well as the audience here and online, and ask for the support of the Institute for Christian Democratic Politics, the organizer of the event, as well as the Martens Center, Wilfried Martens Center. And I would like to ask you to go on with the discussions in the adjoining room. So thanks a lot for the discussion, and I hope that this conference has been valuable for you.
Pane profesore, mohu mít jeden dotaz na vás, úplně z jiného soudku. Jaký je váš